Good morning, everyone. It is 9:31. I put out an APB for our glorious chair. Oh, there she is. Good morning, Chair Hall.
Good morning. Well, I thought it was 9:31. My computer's telling me 9:33. No, it's saying 9:31 on the phone. That's most accurate, I think. Thank you very much for at least trying to start, Vice Chair Maestas. Today's Wednesday, October the 12th, 9:31 in the morning. This is the public open meeting of the New Mexico Public Regulation Commission. I'm Cynthia Hall, Chairwoman, and we'll have a call to order and roll call. Hans, can you take the roll if you're the right person?
Sure, I believe Mike will be running the meeting, but I'll be happy to take roll call. Commissioner Maestas.
I'm here.
Commissioner Byrd.
Surprisingly, I'm here.
Commissioner Fishman.
Commissioner Fishman will be signing on between 15 and 25 minutes from now. I just spoke to him. He's still on his way back from Colorado. I think they're not quite at a place where he can get signal yet, but they're working on it.
Sure. Yeah. Commissioner Vicente Aguilar.
Here.
And Commissioner Hall.
Here.
Madam Chair, we have a quorum. The open meeting can proceed.
Thank you very much, Hans. Let's see, next we have the pledge. Let's see, could we have Patrick Rodriguez do the pledge for us today?
Of course, Madam Chair.
Thank you.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I salute the flag of the state of New Mexico and the Zia symbol of perfect friendship among united cultures.
Thank you very much, Patrick. All right, next item is consideration and approval of the agenda. Does anybody have any changes or additions to the agenda or omissions? Hearing none, let's have the roll call to approve.
Move to approve the agenda as presented.
Oh, thank you.
Second.
Thanks. I've got a motion and a second. Mike, are you available to take the roll?
Yes, I have been actually, but I figured I'd let Hans go ahead and do it.
Okay.
Yes, Commissioner Fishman. I'm sorry, Commissioner Byrd.
Aye.
Commissioner Maestas.
Aye.
Commissioner Vicente Aguilar.
Aye.
And Commissioner Hall.
Aye.
And I am assuming Commissioner Fishman will let us know when he joins the meeting. So the agenda is approved by a vote of 4-0.
Thank you, Mike. Okay, next item is Employee of the Month. And this month, I believe we have our Employee of the Month to be Jason Stanovchak. Did I pronounce that right, Jason? Or James, not Jason, James, I apologize.
Yeah, I'm here to, I nominated an employee for Employee of the Month, Madam Commissioner. So anyhow, my name is James Stanovchak, and I'm the pipeline safety supervisor. So I have 7 inspectors that I work with. I also work with a very fine woman named Tina Sigliano Cisneros, and I nominated her for Employee of the Month. She's the pipeline safety administrator in the Pipeline Safety Bureau at the New Mexico Regulation Commission, and Tina's worked there for more than 10 years. Tina never refuses to help when asked. She has a kind and informative nature and helps me as a supervisor every day with difficult situations. Tina has a diverse understanding of everyone's needs in the department, and I believe that she has the ability to adjust her level of involvement with each employee accordingly. Tina Sigliano Cisneros continues to serve the PRC with dedication and great ability. I don't know if I am to say that the commission congratulates Tina, that would go to you, Madam Commissioner.
Well, thank you very much, James. Yes, I'm happy to congratulate her. It sounds like she's just the kind of person we're proud of here at the commission. I think you stopped me at never refuses to help. That right there says a lot, you know, and to the extent you're willing to help your fellow workers, means you're interested in getting things done here at the commission. And that's what we all need to do, and help each other. So I want to extend my heartfelt congratulations to you, Tina, and I'm very proud of you and the dedicated service you've provided us. Thank you very much.
Good morning, Madam Chair and Commissioners. Thank you so much. I appreciate it. And James, I appreciate the kind words. Thank you.
Do any other commissioners have anything they'd like to say?
Madam Chair.
Yes, Vice Chair Maestas.
Good morning, everyone. Congratulations, Tina.
Thank you so much.
That was quite a glowing testimonial, and we're fortunate to have you.
Thank you.
Thank you. That's all I had, Madam Chair.
Thank you, Vice Chair. Anybody else have any comments they'd like to make? All right. Well, we have a long agenda, so we'll move on. Next, we have introduction of special guests. Do we have any today? Today? I'm not hearing.
Madam Chair, I am unaware of any special guests unless any of the commissioners have someone they want to introduce. And I currently do not have anyone signed up for public comment.
Well, thank you very much, Hans. All right, we'll move on then to consideration and approval of prior meeting minutes. This refers to the minutes of September 22nd, 2022, open meeting. I believe that was the special open meeting having to do with a workshop. Does anybody have any changes or additions to these minutes? Hearing none, I need a motion to approve.
So moved.
Do I have a second?
Second.
Okay, thank you. I've got a motion and a second. Can we have the roll call on this vote, please?
Commissioner Vicente Aguilar.
Aye.
Commissioner Maestas.
Aye.
Commissioner Hall.
Aye.
Commissioner Byrd.
Aye.
The prior meeting minutes for the September 22nd, 2022 open meeting are approved by a vote of 4-0.
Thank you very much, Mike. All right, now we come to the presentation and discussion section. We have a presentation, I understand, from a company called Incline Incorporated. It's in the matter of the implementation and administration of the community solar program. And Incline will provide us with a progress report. Incline is the community solar program administrator. Just reading this item into the agenda. It's in the matter of the implementation and administration of the community solar program. The case is 22-00020 UT. And as I stated, Incline Incorporated will present the implementation progress report from the Community Solar Program Administrator.
Madam Chair,
Yes.
if I may just make a few remarks before we have Mayana and Incline present. I thought it would be necessary and timely to have Incline come on and give the full commission an update on the implementation of our community solar program. They are the third-party administrator. My assistant, Christopher, is the kind of the liaison or contract manager with Incline. And we have been having weekly meetings with Incline, and we're getting to a point where we're very close to finalizing key milestones in the implementation of the program. And so before we do that, I thought it'd be a good idea to have Incline come and brief the full commission and then open it up for any questions that other commissioners might have. That's all I have, Madam Chair.
Thank you very much, Vice Chair Maestas. So with that, Ms. Campbell, please proceed.
Good morning, everyone. So I sent some slides over. I'm not sure if someone has access to sharing them. If not, I could share my screen.
Patrick, can you do that? Is that your role, Patrick?
Madam Chair, I did not receive any slides.
No problem.
Give me 1 minute, Madam Chair. I believe I have that in my inbox that I can pull up.
Thank you.
Cool. So while that's being pulled up, just to introduce myself, my name is Mayana Campbell. I work as the Community Solar Lead for the Program Administrator for the New Mexico Community Solar Program. And the first thing I'd like to say is that, we are absolutely thrilled and honored to be working on this program. So I want to thank you for the opportunity to speak with everyone today. And then to continue as the slides become available, so just to reframe or restate the purpose here, the discussion today is just to update the commission on the status of the community solar program, introduce ourselves since we haven't had the opportunity to meet the broader team yet, share a vision and plan for the program, and then answer any questions you may have.
Thank you. That sounds great. Yeah.
I appreciate the immediate feedback.
Well, I appreciate everything you guys do. And as you know, we're having challenges. So,
so to just kind of keep going there, since these are just introductory slides anyways. So just a little bit of history. So we entered contract with the PRC in early August, and we have been working diligently to launch the program within 4 months. So the original time frame had a 4-month start program administrator to launch date. Oh, thank you for that. So we've been keeping on that path with a projected launch date of December 1st. So actually shaving, I think, about 2 weeks off from 4 months, just so we can get it open while the current team is in place and have some reporting for everyone. So what makes us really excited about this program and why we're extremely grateful for this opportunity is New Mexico's policies on the subscriber carve-outs. It's really, I think, unique to this program in particular, and something we are focused on doing well and successfully. And so we are really focusing on being a customer advocate in this program and ensuring strong consumer protections where we can. Our current priorities include the issuance of the RFP, implementing a program website and portal, and creating education and access for subscribers. So to kind of quickly go through our agenda here, I went through the gave an intro for us. I'll move on next to about who we are, our background, our role as a program administrator, program milestones, and then open it up for questions and answers. So next slide, please. So to introduce us as an organization, Incline is a company devoted to running renewable energy and energy efficiency programs, mainly for utility commissions, state and local agencies, and utilities. We offer highly experienced staff and custom software platform, which allows us to streamline the process and keep most of the work in-house, which is extremely important to us. Our ethos is that we believe it is fundamentally important to work with stakeholders, and we want to thank you again for providing us with this opportunity to speak with you today. And then our historical experience, I believe, allows us to bring applicable ideas to this program and make this a really, really strong program with a focus on that, again, consumer protection component. So we come here today with experience launching and running and maintaining the Illinois Community Solar Program. So we launched that about 4 years ago, implemented it, and then ran it through even another community solar reopening, which was really exciting. And we learned from that, the most important thing is transparency, accountability, and collaboration. So that's what we're really focusing on bringing to this program. As you know, community solar by nature is a complicated product with many participants and stakeholders with varying and vast levels of familiarity with the project. And what we really want to put ourselves in is that consumer advocate role. And our goal is to ensure that capacity is not only utilized, but utilized in an ethical way. So to talk a little bit about the structure, which I mentioned earlier, Incline works to keep as much in-house as possible and leverage our software to minimize the cost of the program. So I think early on, everyone saw kind of the draft RFP, which had many forms involved, many attachments, narratives. What we're actually doing is we reworked the entire RFP to create an online portal experience. So asking all the same stuff, but able to streamline it, be able to pull more data out quickly, and also make it easier for the subscriber organizations, the participants who are developing and owning the projects in New Mexico to get these bids to us, as well as create that environment for a strong consumer protection framework. And then at this time, I'd love to introduce our executive staff. So because we're a small company and we keep everything in-house, our executive staff, our senior staff, they are intimately involved in all of our programs and all of our program launches. So if they can come off mute, we have, I guess, Kevin, I can start with you. If you're able to come off mute.
Hello, everyone. I'll just echo Mayanna's comments. We're excited about this program and happy to be here and look forward to working with all of you and with everyone in the state of New Mexico.
Alex, do you want to go next?
Good morning, everyone. And I as well will echo all the comments so far. We're very excited to be here. I'm Alex Ryan, the Chief Operating Officer of Incline, and we're looking forward to launching the program with all of you and bringing community solar to access to New Mexicans.
Thank you very much, Mr. Quilliam and Mr. Ryan. It's very nice to meet you in person.
We actually have one additional senior staff member here. Mike, are you also on? Maybe not. We also have Mike McMillan, who joins every weekly call with the PRC as well. He's our chief of staff. So every call we have with your organization, we have our founder and CEO, our COO, and our chief of staff on the call. So this is a priority for our organization to make sure that it's launched and launched correctly. So next slide, please. Just an overview of what our scope is and ideally our vision for our role. So generally what the program administrator does is, we support the operations and systems, creating an online portal or creating a procurement process for the bids, awarding capacity, making sure everyone's working compliantly, doing customer service. So taking in calls from subscribers or organizations, consumer protection activities. That has been really important to us, given kind of the feedback we've seen in the public arena on this program. So we are really focusing on creating best practices and creating a toolkit for the subscriber organizations to behave well in the market and attract people in the correct ways. We're also working on the flip side on educational resources for subscriber organizations, low income organizations, on what they should be looking for in a subscription, in a subscriber organization, and just all around create an environment of best practices to ideally keep everyone enrolled in a happy and healthy manner. And then last but not least, the stakeholder resources. So I talked about that on the consumer protection side, but that can also mean things like a program guidebook, a marketing guidebook, FAQs of questions that come into us, making them public for individuals to also build off those ideas. And then in terms of our vision, so I mentioned this earlier, but our goal is implementation through collaboration and execution of lessons learned. So we really focused on consumer protection in Illinois. And I think we're coming to this program with a strong understanding of what great practices mean in that field. So that is our focus, along with a focus of impact. So there's a lot of anticipation and stress when a new program is brought to the market, and we're committed to being communicative and collaborative throughout this process. Opportunities for engagement, potentially software updates, because everything is in-house. If we roll something out and it's something the market is really struggling with, we can make updates along the way. And working groups need be. So we're really excited to kind of continue that process in this state. And then again, just that visibility, communication, customer advocate. And then you'll see on our milestones, which is our next slide, we're weeks away from launching, but we have a lot of stuff to get through. So you'll see everything starts as early on from September 29th through March 31st. So some of the things we have been primarily focused on initially here is one, creating the consumer protection strategy, which is going to take form of best practices within the state. Two, working on county outreach. So working with the counties in New Mexico and a coalition on, what is kind of a standardized process? What should these counties be looking for? Because this is a new program, they're being inundated with requests, and we want to make sure that they are on the right page with us and they are comfortable to reach out to us with questions. And then we also released a low income provider outreach RFP. So because this program has a strong component on the low income carve outs and reaching out to low income facilities, we wanted to ensure we were working with a local organization with boots on the ground that can give us real-time feedback on educational resources that are needed, on going out, speaking to these other groups, and just protecting the low-income facilities or organizations that they're working with externally. So we're really excited for that. That's been released. It's due on 10/21, so coming up here shortly, and really excited to get somebody in place there.
So I have a question about
yes, of course.
So the RFP closes on the 21st of October. When do you have them in place? When do you select and have them in place?
Check my timeline. I believe we have them in place in November, early November.
Okay, thank you.
Mm-hmm.
That's all I had. Thank you.
No, and that's a good question because we want to get ahead of anything. We don't want organizations, these subscriber organizations, going out, partnering with the broader communities and maybe not necessarily having the right education behind them. So we want to ensure that the low income organizations and individuals in New Mexico have the education and behind them to make the right choices for themselves. The next kind of big thing we have then is the announcement of the pre-bid conference. So we're working to get the RFP out early November, out publicly. And then November 17th, we are hoping to host a pre-bid conference for the subscriber organizations to come to us, walk through the process of how they can submit a bid, walk through any questions that they may have. And that is ahead of the 12/1, December 1st program launch. Within that period of November as well, we will be releasing a program guidebook. So again, just iterating how the process works and compliance measures besides it. So we're really excited to get that out and running alongside with our website, which will have all this information on it and also allow the access for these bids to be submitted to us. And then in terms of that, so we'll leave the window open for 60 days for the bid. So subscriber organizations will have until January 31st to submit bids to us. We will do a tiebreaker if necessary afterwards. And then the goal is on March 31st to announce the awards publicly. And in that time, also provide marketing guidebooks, since subscribers will become more relevant once projects are identified, and ensuring again that compliance metrics there. So that is kind of our upcoming milestones, and a lot of work to be done, a lot of things in progress, but this has been a really amazing team to work with. They've given us some wonderful feedback. It's been really collaborative, and I've thoroughly enjoyed it, but we have a lot coming up here, and November is a big month for us. So really looking forward to getting this program launched. And that was our progress update. I don't know if anyone has any questions that they'd like to review with us at this point.
Madam Chair.
Yes, Commissioner Maestas, Vice Chairman.
Yeah, I just wanted to, I mean, it's abundantly clear we're moving forward with the implementation of this program despite some pending actions before the Supreme Court, a stay and an appeal. But I wanted to make sure that the public understands that we're moving forward with this program. Thank you, Madam Chair.
Yes, Vice Chair Maestas, I think that's very wise. I guess I have a question. The project RFP publication, what does that RFP describe?
Yeah, so this program is RFP driven, meaning each project will submit a bid to us. So there are caps on the developers, there's caps on the utilities or the subscriber organization, and each project will submit a bid. It will be scored against kind of all these really cool metrics. Some are very innovative and unique to the state, like subscriber discounts for a portion of the project, working with the local community, workforce development programs. So each project will send us an extremely detailed application with all their construction milestones, everything like that. And the RFP that's going to be released on November 3rd details every question that will be asked, everything that's necessary for a minimum requirement of submitting a bid to us, through how to get bonus points. So it's a really exciting program in that sense.
Do you have any idea at all about how many applications you may get, how many responses to that RFP you might get? I don't know. I don't have a feel for how many entities are out there.
Yeah, I mean, I think this is another thing why this program is so excited. I would say just nationally, people are extremely hungry to work in New Mexico. And from the utilities, we've learned that there are at least 600 plus indications of an application wanting to be submitted. So that's, generally what we see is a project bid usually maximizes the size that they're allowed to submit at, which in New Mexico is 5 megawatts. The capacity allotment in New Mexico for this first year program is 200 megawatts. So if we're looking at 600, I mean, that's going well above and beyond the capacity that is available in the state. So hopefully we'll see some really innovative projects that are very focused on the more interesting points in the RFPs, such as working with local folks and, the discounts and how they're procuring and building these projects, which is great.
That's outstanding.
Yeah, it's everyone's very excited for this program. And so are we.
It's good to hear. I want to recognize that Commissioner Fishman has just joined us. And Steve, this is the presentation from NMPRC. So, and I think you missed a lot of it, but I think a lot of it is summarized here in this graph, if you have any questions. Commissioners, are there any questions from any commissioners? Commissioner Byrd? No? Commissioner Vicente Aguilar? Okay, well.
No question.
Oh, thank you. Thank you very much, Commissioner Vicente Aguilar. Okay, well, Ms. Campbell, thank you very much for your presentation. It's very exciting to see. I hope it moves as smoothly as possible. And I appreciate all your very hard work in helping us here in New Mexico implement community solar, because it's very much needed. So thank you very much. We'll move on to the agenda now. Thank you. To consent action agenda. In transportation matters, we have none. And the utility matters, we have 4. Mike, can you read off the captions, please?
Certainly. The utility matters on the consent action agenda are case 19-00106 UT in the matter of applications for the 2020 broadband program support from the State Rural Universal Service Fund as per 17.11.10.31 NMAC. It's a potential order concerning CenturyLink's first request for disbursements for the Deming project, Hatch X 23.8 Highway 140 project, and Hatch X 25 Highway 240 project. Next case is case 21-00098 UT in the matter of applications for 2022 broadband program support from the State Rural Universal Service Fund as per 17.11.10.31. That's a potential order concerning Sierra Communications request for initial disbursement for Raton Golf Course project. Potential order concerning Baca Valley Telephone Company's request for initial disbursement for Kennedy Road project. Next is case 22-00058 UT in the matter of Public Service Company of New Mexico's application for authorization to implement grid modernization components that include advanced metering infrastructure and application to recover the associated costs through a rider, issuance of related accounting orders, and other associated relief. That's a potential order, initial order rather, appointing a hearing examiner. And finally, case 22-00093 UT. It's an application for approval of El Paso Electric Company's 2022 Renewable Energy Act plan pursuant to the Renewable Energy Act and 17.9.572 NMAC and 6th revised rate number 38 RPS cost rider. And that's a potential initial order appointing hearing examiner. And that's it for the consent action items on the agenda.
Thank you very much, Mike. So,
Madam Chair?
Yes.
Move to approve the consent agenda as presented.
Second.
So I have a motion and a second. Can we have a roll call, please?
Commissioner Maestas.
Aye.
Commissioner Byrd.
Aye.
Commissioner Fishman.
Aye.
Commissioner Vicente Aguilar.
Aye.
And Commissioner Hall.
Aye.
The consent action items are approved by a vote of 5-0.
Thank you very much, Mike. Moving on to regular action items. The first case we have, we have transportation matters first, and we have case number 16-00330-TR-EN in the matter of the petition of the Transportation Division of the New Mexico Public Regulation Commission for issuance of an order to show cause and cease and desist against Danny Capello, doing business as Allstate Moving and Storage Incorporated. Judith Amer will present a potential order on staff's motion to close the docket. So Judy, please proceed.
Yes, good morning, Madam Chair, members of the commission. This matter comes before you today upon a 2016 petition filed by the Transportation Division requesting that the commission issue an order to show cause against Danny Capello, DBA, Allstate Moving and Storage, Inc. And this organization and individual have been the subject of 3 previous orders to show cause. And so that this is the reason I'm here today to explain the long and not very pretty history behind the operation by Mr. Capello in violation of the transportation motor carrier statutes and the transportation division rules and regulations. In fact, I would like to go back to 1995, where the commission filed a case against Danny Capello. At that point, it was the State Corporation Commission. It was case number 95-0658. The allegations, which resulted in a final order of $90,000 in penalties against Mr. Capello and DC Movers, Inc. The order, the reason for the $90,000 was $10,000 for lack of operating authority, $10,000 for advertising and holding oneself out as a mover without authority, $10,000 for not honoring the rates quoted. There were 5 complaints of damaged goods and all of these damaged goods and Mr. Capello not paying for it or compensating these 5 complainants. So that was a $90,000 commission order that the commission filed a transcript of judgment in the district court, but never was able to collect or enforce that order. And then subsequently in 2008, in case numbers 08-00224, Mr. Capello, DBA, DC Movers, and Pro Systems, Inc. Was fined $70,000 and ordered to cease and desist. There were several detailed allegations of respondent perhaps making death threats, filing suit against one of his clients, causing damage to property, moving during the moving, but not being responsible for it. I just want to mention that there were hearings held on both of these cases, and Mr. Capello did not appear in any capacity, individually, as a lawyer or as a corporation. That case, there's also a transcript of judgment filed for the $70,000 2008 case, case number 08-00224. But transportation division and legal were never able to collect that. So then we'll fast forward to December 22nd, 2016, when the transportation division filed the 3rd petition for an order to show cause and cease and desist, alleging that Danny Capello, DBA, Allstate Moving and Storage, Inc. had operated in violation of Transportation Division rules and regulations and the Motor Carrier Act, because he continued to provide transportation household good moving services without an operating authority. In particular, in the 2016 case, it arose from a complaint filed by a Mr. Dante Kubishta and there's an affidavit attached to the petition. Again, he alleges exactly what all the previous complainants alleged, was that that respondent caused damage to his property but didn't take responsibility for it. There were also similar complaints of discrepancies between initial quoted rates and ultimate charges. There also were staff investigated, and there's also advertising online, on YouTube, and other sources, again, without authority. However, so we'll move up. In 2018, staff, despite this, on August 13th, 2021, staff filed an update and recommendation requesting the commission close the docket. That was over a year ago. And then on August 25th, 2021, the commission issued an order for staff and Danny Capello, DBA Allstate Moving and Storage Inc., and Danny Capello individually to enter into a stipulated agreement prior to closing the docket. So the commission requested that staff bring this agreement to Mr. Capello and ask him to sign it. And it doesn't have any penalties in it. It just is an agreement for Mr. Capello to no longer provide unauthorized moving and storage in the state of New Mexico, to no longer actually do the unauthorized moving and storage, that in no time in the future will he ever apply for authority. And however, on October 6, 2022, which is very recently, the Transportation Division Director filed another motion to close the docket on the basis that the parties failed to reach the stipulated agreement. The Division Director stated that to best of staff's knowledge and belief, nothing has changed since August 13th, 2021. Mr. Capello continues to struggle with personal health issues. The motor vehicle used by Mr. Capello for the provision of the transportation services is completely disabled, and no complaints or reports have been submitted to staff, as Mr. Capello has ceased all transportation services. For the foregoing reasons, staff requested that the commission find the matter be resolved without further action and close the docket. So the proposed order would close the docket and grant staff's motion, and I stand for questions.
Commissioners, does anyone have a question for Ms. Amer on this matter?
Madam Chair?
Yes, Commissioner Fishman.
Yeah, Judy, how do we know, given Mr. Capello's past, that it's true that his truck is disabled and that he's got these health problems?
Staff has filed a pleading stating to that effect. Other than that, we don't have any other proof.
Okay, just curious.
And I think that was as I recollect a year ago, that the commission was open to closing the docket as long as Mr. Capello just signed, a very small agreement saying that he agrees to no longer operate, and that he does, and that's it.
So my other question would be, why, if he does have these problems, why would he have any reluctance to signing on to an order as opposed to just saying these things are happening and therefore I don't need to sign an order? I'm a suspicious dude.
Commissioner Fishman, I appreciate your questions. I have some of the same questions. And staff's motion to close the docket was literally 3 sentences. And I read you the 3 sentences. So that's all the information I have.
Okay. I don't want to create more work for staff, but, I'm just concerned anytime a grifter decides to, just be non-compliant, that we just cave. And this feels to me like there should be no problem signing an agreement if the story that Mr. Capello tells is the truth. And forgive me for saying so, but I feel like this could very well just be another scam on his part.
Well, age might have something to do with it. It's been like 27 years since the first case was filed.
Yeah, no, I hear you.
Is that all you have, Commissioner Fishman?
That's it. Yeah, that's it.
Yeah, I had, I guess, a similar question too. How do we know this is going to be the end of what we hear about Mr. Capello? And I was curious why we weren't able to collect in the past. I mean, I guess, I suppose he claimed he didn't have the money, but do you know what happened? Did he file bankruptcy, or how did he avoid not paying any of those fines? And does that reflect any shortcoming on our part that we need to deal with? Or?
Well, I don't know exactly why he didn't pay, except he never responded to any motion, any petition, didn't appear at any of the hearings. And so I don't know how aggressively the commission pursued it besides filing a transcript of judgment. There probably after that, they could have tried to collect, but it seems like no one at the commission did. So again, anything else I would say now, I don't have any personal knowledge. Just from looking at the file, that was all that was done to collect, was create the transcript of judgment in the district court. And then it would be served on him. But again, he never responded to anything. So, and when you look at the court file, he didn't respond to that either.
So he never responded to any requirement we issued for him to come and appear. And he never responded to any requirement to appear before district court either.
Right.
Right.
Exactly.
And and there was a district court judgment against him more than once. Is that right?
Yeah, there's 2 of them. And they're attached to exhibits to the 2016 petition. But that being said, and I have to, in 2011, the commission issued an order closing those 2 dockets and saying that, and in the 2016 petition, staff alleges that they don't know the basis for it, but it appeared that staff felt like they were not going to be able to collect those judgments.
I see. So, I know in towing cases, our staff goes out and to the site of the business, of the towing business, to investigate if there's a claim that a car has been towed improperly and, you know, the owner can't retrieve it and things like that. Does staff have any practice of visiting moving company locations to investigate?
Well, yes. In all of these 3 order to show cause cases, staff went out and got actual information, affidavits. So yes, staff has gone and filed affidavits in support of each one of these 3 petitions for orders to show cause.
I see. And so staff's final advice is, well, their position was that they wanted to be able to sign an agreement with him, but he didn't appear at the commission to sign, and I don't suppose anybody took the agreement to him to sign. I mean, is it a mobility issue now at this point? He can't travel or something?
You know, those are all questions that, as I said, staff's motion for an order to close the docket was 3 lines, just saying that staff, Mr. Capello had health issues, that his vehicle was operating. That was it.
Okay.
There was no background such as investigator, you know, went out, requested that Mr. Capello sign it. Mr. Capello said no. There was no affidavit that said investigator went out and saw that Mr. Capello was unable to walk and was bedridden. You know, there was, I'm making this up, but there was nothing more than the 3 sentences I've read you.
I see. But general counsel's advice that we should approve this order closing this docket. Then.
Madam Chair.
Oh God, sorry.
And one thing I would like to add, you know, and this would just be speculation, but because staff again did not actually say it, but I think they feel like they need to you know, put their efforts on actual things that are happening now, and that this appears to them to not be a live issue anymore.
I see. But so the most recent move he performed for any, well, never mind. I
the most recent complaints that they received were in 2016. 2016.
2016, okay. All right. Well, thanks very much, Judy. I appreciate that information. Commissioners, any further discussion on this? Anybody have any questions for Judy or any wish to discuss? Okay, then I need a motion. Anybody want to move this order?
Madam Chair.
Yes.
I'll move the order as presented.
Thank you, Commissioner Byrd. Do I have a second?
Second.
Thank you, Commissioner Vicente Aguilar. We've got a motion and a second. Can we have the roll call?
Commissioner Maestas.
No discussion, and aye.
Commissioner Fishman.
No.
Commissioner Vicente Aguilar.
Aye.
Commissioner Hall.
No.
Commissioner Byrd.
It's a long agenda. You don't need discussion. Aye.
The order is approved 3-2.
Okay, thank you very much, Mike. Moving on, let's see, our next case is a utility matter. It's number 19-0099 UT. In the matter of the amended application for approval of El Paso Electric Company's amended 2019 Renewable Energy Plan and 2020 Renewable Energy Plan pursuant to the Renewable Energy Act and 17.9.572 NMAC and third revised rate number 38-RPS cost rider. And then case number 19-00348-UT in the matter of El Paso Electric Company's application for approval of long-term purchase power agreements with Hecate Energy Santa Teresa LLC, Buena Vista Energy LLC, and Canutillo Energy Center LLC. Russell Fisk will present the potential order concerning El Paso Electric Company's verified motion for expedited approval of amendments to two purchase power agreements. A potential order concerning El Paso Electric Company's motion for leave to file a reply, a potential order concerning El Paso Electric Company's motion to withdraw motion for expedited approval. So Russell Fisk, if you're available, please proceed.
Thank you, Madam Chair. Commissioners, can you hear me?
Yes.
Okay, great. You heard a list of different possible proposed orders. The only proposed order that I have drafted concerns the motion to withdraw the verified motion for expedited approval of the two PPA amendments. This is because of the last open meeting at which this matter was discussed. The commission was waiting to hear from, the commission had just received the day before EPE's motion to withdraw the verified motion, which is the subject, the primary subject of this docket now. So the commission was waiting to receive, was aware that there would be oppositions filed by the Attorney General's office and by the city of Las Cruces, and wanted to wait to see those oppositions. At that time, the commission did have before it a proposed order by Commissioner Fishman that would have dismissed or denied the verified motion for expedited approval without prejudice and imposed penalties, and also a potential order that would have denied the motion or dismissed the motion with prejudice, or deny the motion with prejudice. So, and those are still possibilities. I've only presented an order on the motion to withdraw because my sense was, since the commission was waiting to see the oppositions to the motion to withdraw, that the commission was going to was interested in proceeding on the motion to withdraw. But the commission could also consider those old orders, and I can, if the commission would like to do that, I just want to make that clear. But for simplicity's sake, I'll just go forward with this proposed order. So the proposed order that I've drafted would deny the motion to withdraw the verified motion for expedited approval of amendments based upon the arguments stated in the response in opposition that was filed. There's a joint response that was filed by the city of Las Cruces, the Attorney General's office, and Mary Lee Souls. But as I noted in the memo, the commission could go either way on this particular motion, because the crux of the dispute, in the motion is how to proceed, what procedure to use. Then the motion to withdraw, EPE asked to withdraw the verified motion that it had filed in these two dockets, 1999 UT and 19348 UT, which are the dockets in which the PPAs for these two projects, the two Buena Vista projects, were initially approved. As you will recall, NextEra notified, which was the PPA provider, or there were actually two LLCs set up. There's an LLC set up, Buena Vista Energy LLC for these two projects, but it's controlled by NextEra. NextEra informed EPE earlier this year that it would not be performing under those PPA agreements due to the fact that NextEra was not able to perform all of its obligations for various projects due to the supply chain, the global supply chain issues, and specifically the investigation by the U.S. Department, U.S. I think the U.S. Department of Trade, State Department, something like that, with regard to tariff practices of certain suppliers of solar panels in Southeast Asia. So,
that's the Commerce Department.
Commerce Department. Thank you. Thank you, Madam Chair. So the verified motion, as you recall, just giving you a little, Commission may remember all this, but so quickly just finish the summary. NextEra had basically announced its intent to default on these particular two PPAs. And then EPE began renegotiations with NextEra and arrived at the two amended PPAs for the two projects that were included in the verified motion. Now, just another reminder, PPA number one was for a project that would be 100 megawatts of solar generation and 50 megawatts of battery storage. And that's the amended PPA for which the underlying PPA had been approved in docket number 19-00099 UT. That one was for 19-00348 UT. And then the other project was for a much smaller project, 20 megawatts of solar, that was approved in 1999 UT, which was EPE's 2019 Renewable Energy Plan application. So in the motion to withdraw, EPE states that it would like to withdraw its verified motion for expedited approval of those two amendments so that it may refile approval of the amendments in two new dockets, one being for the smaller 20 megawatt project, which was primarily for the purpose of RECs to comply, obtaining renewable energy certificates to comply with the Renewable Energy Act, that would be in EPE's 2022 Renewable Energy Act plan filing. And EPA has actually filed that. That was on the consent action agenda, and the commission voted to send that to a hearing examiner. And it does include that the 20 megawatt PPA with regard to amended PPA, and that the other project would be filed in a separate docket, a new docket, requesting approval for those amendments. The amendments to that PPA. So that was how EP wanted to proceed, and then these two dockets would be closed again, essentially. The parties to the joint response in opposition, again, that was the City of Las Cruces, the New Mexico Attorney General, the New Mexico Office of the Attorney General, and Marilee Souls. Oppose that approach. Now I'm looking at the memo on the top of page 2, if anyone's following along, or page 3, excuse me. In their joint response, I'll refer to them as the joint parties. They oppose that approach, and that they say, first and foremost, is that litigating a single unified set of facts in two dockets is inefficient and duplicative and could produce inconsistent results. The joint parties also state that they understand that the proposed amendments may turn out to be the best path forward. I think the commission, has discussed why this may, the amendments, the renegotiated PPAs, may provide a better price than EPE could get by doing another RFP because prices for solar energy are currently rising given the supply chain problems and other issues. But the joint parties state that they strongly believe that the commission will be able to make that determination in the most efficient and informed manner by maintaining the current docket, which is actually two dockets. The joint parties argue that the facts relevant to the proposed amendments of the two projects, the two PPAs, appear to be identical. And they further contend that in the motion to withdraw, EP has put forth no reason why it would be appropriate, more expeditious, or more efficient to conduct two proceedings on the two proposed PPA amendments. They further argue that litigating virtually identical issues in two cases would result in duplication of every aspect of the process, duplication of testimony, assignment of hearing examiners, issuance of notice to customers, intervention, discovery, et cetera, possibly two hearings, two RDs, et cetera. So the proposed order would have the commission find that the motion to withdraw should be denied based upon the joint parties' arguments. The proposed order would have the commission reject, however, the excessively detailed procedural recommendations in the joint response. The joint response has a very long and detailed proposal for how the matter should proceed in these two dockets. The proposed order would state that the commission believes that a hearing examiner in consultation with the parties will be able to arrive at an optimal procedure for this matter. I think that the hearing examiner can take all those detailed recommendations into account should the joint parties wish to present them to the hearing examiner. I don't think the commission needs to lock all that in at this point because the proposed order would send this matter to a hearing examiner, and the proposed order would send it to the same hearing examiner, Angelica Anaya Allen, who was today assigned the Renewable Energy Act filing by EPE that includes that 20 megawatt project, the second project, the amended PPA for the second project. The proposed order would have the commission recognize that REA Renewable Energy Act plan has been filed, and that it should be assigned to that same hearing examiner to avoid duplicative efforts and inconsistent results. Just to sort of give the gist of the two of what the commission might want to consider in deciding whether to adopt this order or to instead grant the motion to withdraw. I've done a motion in order to deny the motion to withdraw because I would agree with the joint parties that these two PPA amendments that most issues that will need to be decided and factual issues that will need to be determined are common to both because they both, NextEra decided to, default on both of these agreements. EP chose to go forward with renegotiating both of these agreements. And there's a common major question, which was that the best course of action? Was that are these the best options for ratepayers of EPE in the absence of any information about the broader market in general, that would be the other possibilities essentially for providing that energy through an RFP process. Those are major questions that would, and factual issues that would be common to both of these. I think the joint parties are right about that. Now, but on the other hand, presenting them these amendments in one, the Renewable Energy Act Plan docket for the 20 megawatt project makes sense because it's part of that plan. And part of approving the first version of that PPA, was how well it fit into the 2019 plan. So this would be the 2022 plan. Now, like I said, because that's already been filed, I think the way that could be approached is that with the same hearing examiner conducting both proceedings, the proceeding here and also the proceeding for the REA Renewable Energy Act plan, that it could be apportioned properly between the two sets of proceedings. In other words, if the commission adopted my proposed order, then in this docket, everything that's common to both of the PPAs would be determined, and then there could still be a determination in the other docket 2293, I believe, that as to whether the amended PPA for the 20 megawatt project is a proper fit for the Renewable Energy Act plan. And then in this docket, there would be also the larger project, the 100 megawatt PPA number 1, 100 megawatt solar, 50 megawatt battery storage. The same factual issues and questions as to the reasonableness of the way that EPA proceeded by going forward with renegotiation instead of conducting a new RFP, would be decided in these two dockets as basically a consolidated docket. So with that, I will take any questions.
Madam Chair?
Yes, Commissioner Fishman.
I think Russell's come up with a very sensible approach to this. I trust our hearing examiners to be sure that we hit all the due process issues. I don't think we need a detailed order that dictates to them how to operate this, other than, if there truly is a time constraint to get these, what appear to be good deals in place, that they'll figure out a way to deal with that in the process they put together in the hearing. So I would suggest we just move the order.
Is that a motion then?
Yes.
Okay, commissioners, I have a motion. Do I have a second? Second it. So we have a motion and a second. Yes, Commissioner Vicente Aguilar.
When you're ready, I'd like to make a comment.
Well, I think we're ready right now. We have a motion and a second, and discussion is in order at this point. So I would appreciate hearing your comment. So please.
Thank you. Thank you, Madam Chair. I just wanted to express my concern of how this was handled. I think it's important for El Paso Electric to understand that we're very cautious, and we don't do the analysis. We expect our experts on our staff to give us the on-point numbers. And when our general counsel's office, when he reads through the lines of all the things that he has reviewed up to this point, that's for the public to understand. That's for the public to learn. But beforehand, we've been following this case since July 29, 2022. And not only do we prepare for the meetings to read through all the material, but the way that I do my job is I think about the company, I think about their background, and I also think about the rules that we have in place such as the renewable energy for electric utilities, their portfolio procurement. That is the highest. It's at a high level of review process. We can't listen to one utility company and expect our draw to make a decision. That's not the way that I review the material. There's some sensitivity analysis that we need the true numbers. And I also feel that there was insufficient evidence by El Paso Electric. And I want to make sure that we have the complete record. Those are my remarks, Madam Chair. Thank you.
Thank you, Commissioner Vicente Aguilar. Any other commissioners wish to say anything in this case? Comments or questions?
Chair.
Yes, Vice Chair Maestas.
Yeah, I agree with Commissioner Fishman. I think Russell's approach, to this case, I think is sound and makes sense. And we, we've been, pursuing, answers to difficult questions regarding resource adequacy, and we need to make sure, despite, I think, the delay in bringing this matter before the commission, we need to keep in mind that many of these projects need to be operational to avoid any summer peak challenges that we might have. And so I think that this, this order balances adherence to our procedures and yet considers the need to not waste any more time than what's already been wasted. So I like this approach, Madam Chair. That's all I had.
Thank you, Vice Chair Maestas. Commissioner Byrd, any comments?
No, Madam Chair, thanks.
Okay, thank you. So I would just add to my fellow commissioners' comments that I think Russell suggested a good way to proceed. I, agree. We need to conserve everybody's resources, not just our administrative resources, but all the parties' resources, and just proceed in this docket with this case. And I completely concur with Commissioner Fishman that I'm sure the hearing examiner can determine what further evidence needs to be presented and how best the parties can manage a timetable and what timetable would best suit them. So to proceed with the hearing, or however they manage to proceed, but I believe it would be a hearing in this case. So, well, with that, having said that, I guess we have a motion and a second, and we've discussed. So, Mike, can you take the roll call?
Commissioner Fishman.
Aye.
Commissioner Byrd.
Aye.
Commissioner Maestas.
Aye.
Commissioner Vicente Aguilar.
Aye.
Commissioner Hall.
Aye.
The order is approved by a vote of 5-0.
Thank you, Mike. Okay, so moving on, we come to item number 8. It's case numbers 22-00020 UT. In the matter of the implementation and administration of the community solar program. Case number 22-00240 UT. In the matter of the compliance filing of Southwest Public Service Company pursuant to 17.9.573.9 NMAC. And 22-00243 UT. Application of El Paso Electric Company for approval of tariffs necessary for implementation of the New Mexico Community Solar Program and accounting order. Russell Fisk will, along with assistance from Christopher Dunn and Arthur O'Donnell, I believe, present the Well, let's see. We have a utility division staff's presentation of its recommendation concerning advice notices, potential order concerning staff's recommendations, requiring corrections to non-compliant advice notice provisions, requiring utilities to confer with commission advisors and program administrator concerning forms and agreements. So whoever will be speaking first, please proceed.
Yes, Madam Chair, I believe Christopher Dunn will be presenting staff's recommendations first.
Okay. Thank you, Russell.
All right. Thank you, Russell. Thank you, Madam Chair. Just to make sure, can everybody hear me?
Yes, we can. Good morning, Christopher. All right.
Morning,
will
Madam
you
Chair.
be presenting any slides or are you just speaking?
You know, I thought through that a little bit. I'll be honest with you, Madam Chair, and it gave me a different appreciation, even greater than before, for Office of General Counsel's presentations. But I'm just going to give you my face today and kind of read through my recommendations rather than giving you a slideshow. So hopefully that's all right.
That's fine. That's fine.
Fantastic.
We don't often have staffs present, so I wasn't sure how you wanted to do it, but please proceed.
Yes, I'm used to being in listening mode, so it's kind of a different position today. I get to present to you all, and I'm looking forward to doing so. But again, thank you, Madam Chair, and thank you, Commissioners, for allowing me to come and present today. My name again is Christopher Dunn. I'm an economist with the Utility Division in the Economics Bureau, and I'm the individual that reviewed the advice notices from each of the IOUs related to the implementation of the Community Solar Program. My plan here is to give you a brief overview of each of the advice notices and then staff's recommendations, beginning with SPS, then PNM, and then EPE. That's the order that they came in, so if that's all right, I'll go ahead and proceed with that.
Please do.
So, thank you, Madam Chair. Beginning with SPS, SPS's advice notice number 309 was filed on September 12th, 2022. Of course, it was filed pursuant to the Community Solar Act, and particularly the Commission's Community Solar Rules, specifically Section 17.9.573.9 requires the utilities to file all tariffs, agreements, and forms necessary for implementation within 60 days of the effective date of the Community Solar Rules. So SPS's application came in again on September 12th, and contained in that filing was the original rate number 87, SPS's Community Solar Program Credit Rider, original rate number 88, which is SPS's Community Solar Subscriber Organization Agreement. And then there was supporting testimony from two SPS employees in support of advice notice number 309 as well. SPS's rate number 87 describes how the company proposes to credit their customers who subscribe to a community solar facility for the generation that would be attributed to their account. And this is where staff found an issue that I'd like to discuss with you here. Specifically, SPS's proposal deducts transmission costs from the total aggregate retail rate in calculating. Of course, this issue has come up before the Commission previously in the rulemaking process, and ultimately the Commission's rules stated that transmission costs were not to be deducted when calculating the solar bill credit rate. For this reason, staff does not feel that SPS's advice notice is filed in compliance with the Commission's rules, and I'm recommending suspension for advice notice number 309. I will note that there are protesters, that there are organizations or groups that have filed protests against SPS's advice notice filing as well, and I can review those later if you'd like.
Christopher, you're fading in and out a little bit, so I don't know if you can get closer, or maybe be careful about modulating your voice, because suddenly mid-sentence I'm losing you sometimes.
Well, it may just be, yeah, if you can point your face to the camera more, or to the, maybe that helps for me. It seems if I
yes, I have.
There we go.
These headphones in, but perhaps the microphone, I just switched it, so hopefully it'll come through better on the different microphone I've selected.
So Christopher, I understood you to say that in addition to staff's issues that, and this is where you were fading in and out some, that other folks had filed issues with, similar issues with SPS's proposal?
Yes, Madam Chair, Commissioner Fishman, and Commissioners, that is correct. Other other entities have also filed protests against SPS's proposal here.
Okay, and you know, I haven't looked at the record on this, but who were those folks? Do you happen to know?
Yes, the protesters were Coalition for Community Solar Access, Renewable Energy Industries Association of New Mexico, New Energy Economy, and Cypress Creek Renewables. I will note that Cypress Creek Renewables filed comments in docket 22-00020 UT that were comments generally for each of the IOUs. And of course, that's the implementation docket. So those were kind of filed in a different docket, but they were also included.
Okay, thanks. Go ahead with your presentation. Appreciate it.
Absolutely. Moving on to PNM's filing. PNM's advice notice number 591 was filed on September 14th, 2022, again, pursuant to the same statutes and rules. PNM's advice notice number 591 included original rider number 56, the community solar rider, original rider number 57, the community solar administrative cost rider, original rate schedule number 37, which is the community solar program tariff. And then I'll also note that PNM requested in its filing the Commission's approval to establish a regulatory asset to accumulate administrative costs. In support of its filing, PNM also provided testimony from 4 employees. Reviewing the specifics of this, rider number 56 is provides the dollar per kilowatt hour credit rate that PNM proposes to offer subscribers in exchange for their monthly generation. There were a couple of items that staff identified with rider number 56 that were of concern. First, the rider imposes limitations on carrying forward bill credit amounts. It also establishes an unavoidable monthly minimum charge that cannot be offset by the community solar bill credit rider. So between those two, first, you have the component wherein the rider cannot fully offset the bill because there's a monthly minimum charge that's established. And then PNM has proposed, it seems, it's a little unclear from the wording that they use in their filing, but it seems to be a limit on how much of a carry forward amount can be carried forward on a customer's account if there is generation in excess of what their billing would be based on the credit amounts. So staff is concerned that this might end up restricting customers from actually receiving the full value of the generation that they are subscribed to at the community solar facilities. Additionally, rider number 56, the same rider, places limits on who is eligible to subscribe to community solar by prohibiting customers who currently have behind the meter generation or are receiving service through a voluntary renewable energy program. Looking at rate number 57 next, staff is concerned that, and this is the administrative cost rider, staff is concerned that this rider may disproportionately impact some subscribers because PNM doesn't actually state a rate at this time for recovery of these administrative costs. They state that they will file a rate once the program launches based on the costs recorded in the regulatory asset, and that the rider is calculated by allocating the amount recorded in regulatory asset to each applicable customer class to determine dollar per kilowatt hour rate. Basically, based on this information, staff is concerned there may be, again, disproportionate impacts to some subscribers. For example, early adopters versus later subscribers, depending on how much is collected in the regulatory asset and how those costs are distributed to the customers via that dollar per kilowatt hour rate for recovery. I'll also know that PNM doesn't provide very much detail as to the regulatory asset that's requesting from the commission, requesting permission from the commission to establish. And there's just not a lot of information on things such as whether or not the rider would carry, the regulatory asset would have carrying charges or frankly, very much detail otherwise. And then I'll note that rate schedule number 37 is a pretty extensive set of agreements between PNM and the subscriber organizations. Essentially, it comes in the form of a PPA that again is quite extensive with several exhibits, I believe about 10 exhibits attached to it. There are additional agreements and forms to be entered into between the subscriber organization and PNM, and staff believes those warrant further scrutiny. For these reasons, staff is recommending suspension of PNM's advice notice number 591 as well. And I will note again that there are protesters that have offered a protest against advice notice number 591 from PNM also. Moving on next to El Paso Electric's advice notice number 279. Advice notice number 279 was actually filed on September 21st, 2022, but EP's filing initially came in on September 14th, 2022. It was deficient of an advice notice, which again was later filed by the company. The advice notice contained original rate number 47, the community solar program rate, original form number 43, the standard contract for community solar form. And then I'll note again that El Paso Electric has also requested permission from the commission to establish a regulatory asset. El Paso Electric's intent with this regulatory asset is stated to be to track bill credit amounts provided to community solar program subscribers that are in excess of the costs that are avoided by El Paso Electric. Again, staff reviewed this advice notice and all filings related to it in its entirety. That rate number 43, pardon me, I'm looking at the wrong item. Original form number 43, standard contract for community solar, had numerous terms to be, again, entered into between the subscriber organizations and El Paso Electric. One thing that raised a red flag for staff, though, was among their other agreements, there was a fee that El Paso Electric intended to impose upon subscriber organizations in the form of $1 per subscriber per month charge to be administered to those subscriber organizations to recover administrative fees. Staff notes that subsection 17.9.573.13D of the Commission's rules does allow a utility to recover administrative costs through a rider that the utilities can apply to the Commission to receive approval for. However, there's nothing said about recovering those costs from the subscriber organizations in the format that El Paso Electric has proposed. Additionally, staff notes that El Paso Electric's regulatory asset they are proposing to establish is, again, to track subscriber bill credit amounts in excess of EP's avoided cost, with the intent of recovering those amounts from community solar subscribers at a future date. Recovery of that regulatory asset from those subscribers is not detailed very much, and staff, again, is concerned that it could disproportionately burden different customers who are subscribers to community solar. Additionally, there is not very much detail provided by El Paso Electric, again, as to the request for a regulatory asset from the Commission. And so for these reasons, again, staff is recommending suspension of El Paso Electric's advice notice number 279. And I will state once more that there are also protests against El Paso Electric's filing of advice notice number 279. With that, I will conclude my prepared remarks and stand for question from the commissioners and Madam Chair.
Thank you very much, Christopher. That was really a good presentation. I appreciate you going through each company's filings. I guess I just want to remark that it's interesting. They all made somewhat slightly different errors. But I would like to open this up. Do any commissioners have any questions for Christopher? Okay, I'm not hearing any questions.
Madam Chair?
Yes, Commissioner Fishman.
Yeah, I don't have any questions. I just wanted to thank Christopher for a very clear, concise presentation. Very much appreciated. And yeah, I'm ready to hear from Russell and Arthur and just round out the picture here.
Mm-hmm. Yes, I do want to concur. This is a very clear presentation from staff and thorough, and I appreciate it. So, Russell, are you speaking next, or do we hear from Arthur?
Madam Chair, I'll speak next. Madam Chair, Commissioners, I'm going to go directly to page 6 of my memo, which quotes directly from the proposed order because it summarizes the approach that I'm recommending, which is also in accordance with what Arthur has recommended.
What page was that, Russell? I'm sorry.
Page 6 at the bottom of the memo.
Okay.
So the proposed order would state that the commission accepts staff's recommendations to suspend all 3 of the advice notices. The commission agrees with staff's reasoning, which is also consistent with the compelling comments and remarks made by CCSA, Coalition for Community Solar Access, I believe, REIA, the Renewable Energy Industries Association of New Mexico, CCR, Cypress Creek Renewables, and New Energy Economy described above. I mean, essentially the comments that were made by all 4 were consistent with what staff is saying. Staff, of course, had some more detail about the specific information it needs, but they're completely consistent in terms of the criticisms of the advice notices. The proposed order would go a little beyond suspension. The proposed order would go a little beyond suspension with regard to SPS's proposed community solar bill credit. The proposed order would have the commission find that it should be rejected immediately as the deduction of transmission costs is in flagrant disregard of the Community Solar Act and the commission's community solar rule. I would just say, a lot of these issues you've heard discussed are issues where more information, is needed for staff to fully evaluate, certain choices that have been made by the utilities. You heard about, the administrative cost rider and things like that. But SPS's inclusion of a solar bill credit that allows for deduction of transmission costs. I mean, that's a central, if not the central bone of contention between the commission and the utilities. And the commission was absolutely clear in its rule that deduction of such costs is not allowed. So SPS's advice notice would be suspended overall. It'd be suspended in part, but it would be actually rejected with regard to the community solar bill credit. And SPS would be required under the proposed rule to file a community solar bill credit advice notice just for that part on or before Friday. That does not allow for deduction of transmission costs. And the proposed order would further say that the commission agrees with the comments in the record. Those are the comments by CCSA, REIA, CCR, and NEE, New Energy Economy. Some of those comments included the recommendation that the commission seek as much uniformity in forms and agreements among the 3 qualifying utilities as is practicable. And that's something that Arthur had already identified as something to work on. It's excellent to have in front of the commission and in front of staff the 3, the approaches that the utilities are looking at for agreements with subscriber organizations, such as agreements with regard to the power that's generated by the subscriber organizations, and also things such as a form of a customer agreement to that allows subscriber organizations to share customer information, or utilities to share customer information with subscriber organizations and vice versa. But at this point, what needs to be done is to take those different versions and achieve some uniformity so that they're as close. There still may be differences among them because there are differences among the utilities that are significant. But the plan would be, as described in the ordering paragraphs, to have Arthur and possibly GridWorks and our program administrator Incline work with the utilities to develop forms and agreements that are uniform to the extent practicable. That's part of the ordering paragraphs. And then finally, the proposed order would state that the commission will not appoint a hearing examiner or schedule a public hearing in this matter at this time. The proposed order would state, which is something that was actually suggested by some of the, I believe by EPE's application, and also in some of the comments by CCSR, REIA, CCSA, REIA, et cetera. The proposed order would state that issues concerning the advice notices will not delay the implementation of the community solar program. These issues can be resolved expeditiously and without a hearing. There are occasions on which an advice notice is filed with an application, in other instances, rate cases and such where a hearing is necessary. I think that these issues can be resolved without a hearing, and that will help keep the commission on track for implementation of the program. So specifically, how this would proceed forward under the ordering paragraphs is, as I said, all three of the advice notices would be suspended, and SPSs would be rejected in part with regard to the credit, and they'd have to SPS would be required to file a conforming credit that would not deduct transmission costs. That'd be on Friday. And then the three qualifying utilities would be ordered to file on or before October 20th, which is next Thursday, I believe. It gives them 8 days. In docket 22-00020, that's the overall implementation docket, the information that staff has identified as necessary for a complete and thorough evaluation of the advice notices. And you heard Christopher Dunn describing, the questions that remain about some of the provisions that, may be perfectly valid, but need more fleshing out, may require, tweaks or small changes, or, may turn out to be, upon further information, unacceptable. But more information is needed on many of those things. And this order would require the utilities to confer with staff prior to filing such information to ensure that the filed information will be satisfactory to staff. So that's a lot to do in 8 days, but that will keep the commission on track on the implementation track that we're currently on. And, the utilities should have this information. They should be able to answer these questions. After all, they did come up with the forms agreements and tariffs for compliance with the rule. So they should be able to answer these fairly quickly and then provide by next Thursday information that will be satisfactory to staff that will fully answer these questions. And then, as I said, the ordering paragraph would order the three qualifying utilities to cooperate with the commission's advisors and program administrator to develop forms and agreements that are uniform to the extent practicable. The three utilities would not have to take any steps at this point. It would be for the commission's advisors, especially Arthur and the program administrator, to contact the utilities at appropriate times in the near future to start that process, to start having those workshops or meetings to accomplish that. So with that, I will take any questions. And also, I believe Arthur is here to take questions as well. Yes, I'll take any questions.
Okay, thank you very much, Russell. Commissioners, any questions for Russell or for Arthur?
Madam Chair.
Oh, yes, Vice Chair Maestas.
I'd like to make a motion to approve the order as presented. I do have some remarks under discussion.
Okay, I got a motion. Do I have a second?
I will
Commissioner
second.
Fishman will second. Okay, I've got a motion and a second, and so let's have discussion. Vice Chair Maestas, you said you had some comments.
Thank you, Madam Chair. I've said over and over that the Community Solar Act is, to me, the most significant energy justice piece of legislation passed here in New Mexico thus far. But I still continue to be dismayed and disappointed that the utilities continue to engage in what's becoming increasingly clear of a pattern of obstruction and delay aimed at hindering the progress of the state and hindering the intent of the legislature, the governor, and the commission in implementing community solar. I think one of the interveners, the city of Las Cruces, did file a protest and complaint about one of the utilities' so-called compliance filings just yesterday in the docket. It's certainly difficult to consider clearly non-compliant filings from the utilities as, compliance filings. So I want to paraphrase the city's comments because I think they apply to all three of the utilities here to a lesser or greater extent across the board. The utilities are wasting time, money, and the resources of this commission, the city, the state, affected municipalities, and the other interested parties here, both the potential beneficiaries of community solar, in particular, low-income families and the developers of the community solar projects, by scattering their obstructionism in various dockets, appeals, and a multiplicity of filings and pleadings. And that doesn't even take into account the actions of the utilities in throwing up unnecessary roadblocks and dragging their feet in working with the third-party administrator that we heard from earlier. So let me be clear, folks, community solar is here and community solar is here to stay. The legislature wants it, the governor wants it, the people want it, the business community wants it, and the commission has issued its rule and is moving forward with it. So rather than continuing to obstruct or delay community solar and the intent of the legislature to the detriment of our low-income communities, I would like to once again ask the utilities to get it together and get on board. Thank you, Madam Chair.
Thank you, Vice Chair Maestas, for those ringing comments. I totally concur in them. Any other commissioners have any questions or comments or discussion? Okay, Commissioner Fishman.
Madam Chair, actually, I'll make more comments during commissioners' comments, but I think that this speaks to the sort of adversarial legal model that we always fall back on. Or we don't fall back on it. It's the defined process that we use. And where there's not an alignment of interests, this is what you get. You get this kind of obstructionism, and these are the rules of the game, and that's what participants do. And it does not serve the public well. So during commissioners' comments, I'll make a couple of suggestions about how we can maybe change the rules of the game so that we have more alignment of interests and that we can maybe move towards a more constructive and timely process. So I'll just leave it at that.
Thank you, Commissioner Fishman. I'll be very interested to hear those comments. Commissioners, any other observations or comments or discussion you'd like to make? Commissioner Vicente Aguilar, do you have? Oh, good. Yes, Commissioner Vicente Aguilar.
Thank you, Madam Chair. I just want to make a remark that I think we are implementing the community solar program in a way that's going to be inclusive for all utility companies, the regulatory commission, and I'm very impressed how keen our staff members are on this particular subject. I'm very impressed with that. And I just feel that, just like the ETA, it's not going to get off the ground smoothly. It's going to take time. And I'm on the other side from my colleagues. I rather listen to everyone. I rather hear what their concerns are from the utilities and just continue to work in a manner that's going to be resolved and positive resolution. That's what I'm looking for. And I think it will work out, but we just need to have everybody at the table, and that's my angle. Thank you, Madam Chair.
Thank you, Commissioner Vicente Aguilar. Commissioner Byrd, any comments?
No, Madam Chair, thank you.
Okay, thank you. Well, I would just say I am also very proud of staff for their professionalism and diligence and all the work they've had to do to, you know, first of all, get the rule done, and now working through these steps of implementation. I'm very proud of our staff and proud of the way they want to proceed. I think it's not a bad idea I think it's a great idea actually to just not go through the process of having a hearing, but instead just meet with the companies to confer with them to help them get their filings corrected. And I think I also heard the suggestion that there be a workshop. I think those are great ideas. And I think that is a good example of how this agency is trying to assist the utilities in being able to perform properly in these programs. And I would hope that going forward, we could have more of a cooperative approach to this. This hasn't been a good start so far, it doesn't look like, but I'm very proud of our staff and the way they've conducted themselves, both through their work ethic and ability to provide some sort of place between the utilities and the consumers where problems can be worked out. So with that said, need a motion. Did we do this part already? No,
yeah, we have a motion and a second.
Okay, we got a motion and a second. Any further discussion? Hearing none. Mike, can you take the roll?
Commissioner Maestas.
Aye.
Commissioner Vicente Aguilar.
Aye.
Commissioner Hall.
Aye.
Commissioner Byrd.
Oh.
Commissioner Fishman.
Aye.
Order is approved by a vote of 4-1.
Thank you, Mike. Okay, proceeding on. We are at case number 21-0059 UT. Did I hear someone say something? No? Okay. In the matter of an inquiry into New Mexico electric utility resource adequacy planning and impact of global supply chain disruptions, Judith Amer will be presenting a potential bench request order.
Yes. Good morning, Madam Chair, members of the Commission. This case number is 21-00159. I'm not sure if there was an error in the agenda, but it's case number 21-00159 and case number 21-00260 in the matter of an inquiry into New Mexico electric utility resource adequacy, planning, and impacts of global supply chain disruptions.
Well, thank you, Ms. Amer. That doesn't appear on my agenda. Maybe I.
Okay.
Old agenda. Go ahead.
That being said, there's the background to this inquiry is that the Commission received responses in this inquiry filed on March 4th, 2022, that the Commission had asked for information from New Mexico's investor-owned utilities on the nature and scope of the risks of adverse outcomes resulting from supply chain issues and on their resource adequacy, and the utilities plan to minimize these risks in order to provide reliable electric services to New Mexico customers. EPE, SPS, and PNM all have filed responses in this docket. Staff, in addition, filed an affidavit of Jack Sidler on May 13th, 2022. Then on August 31st, 2022, the commission issued an order scheduling a special open meeting, which was held on September 22nd, 2022. At that workshop special meeting, there was discussed energy resources for the summer periods of 2023 and 2024. Also discussed by the 3 IOUs were the projected online timing for projects for the next peak seasons in 2023 and 2024. At the workshop, the 3 IOUs did provide valuable information about their planned procurements to address resource adequacy for 2023 and 2024. And based upon the information received in this docket and at the workshop, the proposed order finds that it's in the public interest to require EPE and PNM to respond to the following follow-up inquiries. And they need to file by October 19th, 2022, but of course that date could be changed if the commission chooses. What EPE and PNM are requested to file and serve are, first, copies of any and all RFPs for any type of resource intended to address resource adequacy for 2023 and 2024 that were issued since the beginning of 2022 or will be issued in 2023 or 2024, 2022 or 2023 for either firm generation or market generation. So any and all RFPs for any type of resource intended to address resource adequacy for 2023 and 2024 that were issued since the beginning of this year, 2022, or will be issued in the remainder of this year or next year in 2023 for either firm generation or market generation. Second, each PNM and EPE shall provide a current loads and resources table for the years 2022 through 2024. And then EPE, we have a specific request for EPE, which is to provide a copy of its demand management plan, including, but not limited to, how it will communicate to customers regarding demand management during peak seasons and contingency plans to avoid or implement rolling brown or blackouts during peak seasons. Then an inquiry just to PNM is PNM shall provide its plan for the actual replacement power versus the proxy for the Four Corners power plant. And these questions were developed by Commissioners Maestas and Commissioners Fishman. And, you know, I stand for questions.
Thank you very much, Judy. Commissioners, any questions for Judy, or I guess the authors of this bench request order? Commissioner Vicente Aguilar? Anything?
No questions, Madam Chair. Thank you.
And Commissioner Byrd?
No, ma'am.
Well, I just have one question to either Commissioner Fishman or Vice Chair Maestas. I see you're asking for copies of any and all RFPs for any type of resource intended to address resource adequacy for 2023 and 2024 that were issued since the beginning of 22 or will be issued. At least with respect to the ones that have been issued, are you interested in any information concerning responses to RFPs for which there has been time for a response? Is that something you'd be interested in adding to this request? Just pops into my mind.
Madam Chair, certainly, I think that's a great addition. Thank you for suggesting that.
Okay. Okay, well.
It's fine with me.
All right, Commissioner Fishman and Vice Chair Maestas, if you don't mind, I'd like to make a friendly amendment to that effect. Yes, Ms. Amer?
Yes, I believe there's a protective order issued in this case. And so those responses could be filed pursuant to the protective order.
Great. I think it goes without saying that we would not want to reveal the identity of any respondent and are only interested in the types of resources and the cost, the price, the cost, that is. Do I need to work out the language at this moment, Judy?
Well, I would suggest identity of responses omitted, just the type of resource and price is what you're.
Yeah, that's what I'm interested in. And Commissioner Fishman, can you think of any alteration that you would like to see?
No, I think you're headed the right direction there.
Okay. All right. Thank you, Judy. If you could add that language to that sentence, that would be fine.
I can do that.
All right. Great. Okay. Well, let's see. I guess I'd like to make a motion to amend this order to include language that would request information on responses to any RFPs which have been received by the utilities in connection with the type of resource and the price involved, with obviously no identity of bidders revealed. So I think I'd like to move the order with that friendly amendment attached, and I guess I'll need a second.
Second.
Okay, thank you, Commissioner Fishman. So we have a motion and a second, and we have the roll call on that.
Madam Chair, if I may, I just wanted to, mention that this is a result of, what we learned at the workshop regarding resource adequacy, and to also remind everyone that we're vigilant in maintaining a dialogue and a focus on resource adequacy with a focus on summer 2023 and summer 2024. We, as you know, are meeting bi-weekly, Commissioner Fishman and I, and key staff members, to ensure that this agency is doing all it can to ensure that we keep the lights on, or that we ensure that the utilities keep the lights on. So I wanted to just thank staff for supporting this entire effort, and also to mention, and this was a recommendation made by Commissioner Fishman, that we do intend to have a follow-up workshop, maybe tie up some loose ends on resource adequacy, but with a renewed focus on transmission. So we're going to start working on that and get a much tighter agenda together, maybe than we did in the previous workshop. I don't know, Commissioner Fishman, if you want to add to that.
Well, mostly just thank you, Commissioner Masses, for your dogged pursuit and leadership and focus on this issue. It's made all the difference, and I just want to pass on my thanks.
Thank you.
Okay, so I believe we have a motion for an amended order and a second. Do we have any other further discussion on this? Hearing none, can we have the roll, take the roll?
Commissioner Basenti Aguilar.
Aye.
Commissioner Fishman.
Aye.
Commissioner Byrd.
Aye.
Commissioner Hall.
Aye.
Commissioner Maestas.
Aye.
The order is approved by a vote of 5-0.
Great, thanks very much. Moving on to item number 10. We have case number 22-00097 UT in the matter of applications for 2022 broadband program support from the State Rural Universal Service Fund as per 17.11.10.31 New Mexico Administrative Code. Russell Fisk will present a potential order granting and denying applications. So Russell, please proceed.
Yes, Madam Chair, Commissioners. So I have gone ahead and drafted a proposed order based on the prioritization criteria that the Commission has used in the past two dockets of applications for broadband program funding. That is, first, to prioritize proposed projects that would serve areas unserved by broadband, as that is defined in the Commission's SRUSF rule, over proposed projects that would serve areas underserved by broadband. And within those categories, to prioritize projects with lower projected costs per customer served over those with higher projected costs per customer served. And the proposed order that I prepared would grant funding to all 11 of the proposed projects that would serve areas unserved by broadband. And then among the proposed projects that would serve areas underserved by broadband, there would be 18 proposed projects that would be awarded funding, which is, of course, not all of those that were the subject of applications. The proposed order would award a total of $11,872,279.92 in funding, which is precisely the amount available for the broadband program this year, as was reported to me last week by the fund administrator. If the Commission will recall, last year there was about $11,579,000, I believe. So there's a little more available this year, but it's about the same amount. That is what's left over within the $30 million statutory cap on the SRUSF after all other obligations are funded. So I show on, and I'll get to how I got to exactly the awarding exactly the amount, because of course the projects that would be awarded funding do not add up precisely to that amount. There'd be quite a coincidence if they did. Let's see. But first, before I get to the spreadsheet, let me just give a little bit of information about, just a reminder of what the Commission had before it, has before it with regard to the applications in total. There were a total of 15 applicants. In other words, 15 different carriers that submitted applications in this year's cycle, requesting funding for a total of 43 proposed projects. The total cost for all of those projects is projected to be about $39.9 million, for which the applicants sought funding for the broadband program, and the total amount of $30,990,000 et cetera, and change. And again, this order would award the full 11,872,000, et cetera, available in funding due to the $30 million cap. Let's see. Let's go to. Okay. Well, I'll continue with the memo. I'm on page 2. The proposed order would have the commission find that all of the applications, as I said, that would serve areas unserved by broadband should be granted in accordance with the general prioritization of unserved over underserved areas, consistent with the commission's past practice and consistent with the broadband program provisions of the SRUSF rule, which provide for that prioritization as an option for the commission, but not as a requirement. With regard to the proposed projects that would serve areas underserved by broadband, the proposed order would have the commission prioritize projects with the lowest projected cost per customer served. But the proposed order would make 3 exceptions to this prioritization in order to grant funding to 3 particular projects. Let's go now to Exhibit A, which is, this is the spreadsheet that was provided to the commissioners by staff, prepared by Eugene Evans back when staff made its August 31st presentation of the applications to the commission. This would become Exhibit A in that. I'm sorry. Let me get this open. I don't know if the right one in front of me. Here we go. Okay. To this dispositive order, just as in the last 2 orders issued by the commission in this docket, we have the same spreadsheet attached, but showing which projects would be funded and which would not, by reference to the 5th column, column E. I've changed the title of that column from total funds requested to total funds awarded. So if you're looking at Exhibit B, you can see that first, there's a section of proposed projects serving unserved areas. All of those would be granted, totaling $4,240,196 in funding for those projects. And then there were many, many projects that would serve underserved areas. And you can see which ones would be funded by which ones have an amount in the total funds awarded column. So you see, as these are listed in priority of lowest cost per customer to highest, for the I've just gone down through the list, and the first, from column 19, ComNet Wireless's Chimayo broadband project through on row number 35, Windstream's Capitan One Exchange Windstream's San Ysidro Exchange project. That's a solid list, continuous list. All those projects would be awarded funding pursuant to the prioritization of those with lowest cost to highest cost. Then you'll see the deviation or the exceptions to that prioritization that I'm recommending as a possibility to the commission, which is that, the next project under that type of prioritization would be CenturyLink's School of Mines Road X309 project. The total project cost projected is over $2 million, and the amount requested, I have to look at the other spreadsheet for this, the amount requested for that project was, excuse me, I'm just going to find
Russell, excuse me.
Yes.
I thought you said one of these Windstream projects was San Ysidro, but what you have written down was their Capitan One Exchange and their Tierra Amarilla Exchange.
Yes, I'm sorry. I'm kind of backing into that. What I was trying to describe by looking, I'll match that. I'm going to match this up looking at the spreadsheet with what is said in the proposed order. So first, what I was saying is just going through the underserved, the project serving underserved areas, the second section of the spreadsheet, you'll see that the proposed order would grant all of the projects which are already prioritized, lowest to highest cost per customer served. And that goes continuously through row 32, which is Windstream San Isidro project. And then, so that's going, I just want to point out that, those awards would be as per the prioritization criteria, not without any kind of deviation from it. But
now, say that again. I didn't quite understand what you're getting at. They're not going to be, they will be receiving funding, but on what criteria?
Madam Chair, Commissioners, this spreadsheet is set up in order. It reflects through the order that the projects are listed, the prioritization criteria. So if you go from the top to the bottom, the order would award all of those projects serving unserved areas. And then for the projects serving underserved areas, which is the second section, that section is in order of lowest cost per customer served to highest. And so by just simply following the list until the amount of money available, the $11.8 million is exhausted, the commission would be following those two prioritization criteria precisely. Does that make sense?
Mm-hmm.
Okay, so,
yes.
So the proposed order would do that, would follow the prioritization criteria precisely right through till you get to Windstream Communications Capitan 1 Exchange project. That's why that's a continuous, if you look at column 5, it's a continuous, for all those projects, the total funds awarded, there are funds awarded. You see that from looking at the, I'm sorry, through the through Windstream San Isidro Exchange project. I'm sorry, that's why it's confusing.
Right.
So those right through that project, which is on the row 33, all of those projects are prioritized by those two criteria, and they would all be granted funding. Then where the deviation or exceptions begin is with row 34, CenturyLink's School of Mines Road project. And that is because that project CenturyLink requested 1.5 or 1,542,000, et cetera, in funding for that project. And that would put the total amount over the $11.8 million at that point. So the proposed order would make an exception and not fund that project for that reason, because it's simple as the commission doesn't have that much available. And it would skip to the next project, the Windstream's Capitan Exchange project, which could be funded in the full amount requested of $416,573. Then the proposed order would skip Tula Rosa's Dungan FTTH project, which requested funding in the amount of $1,464,147. Again, that would put the total amount over 11.8 million. There simply isn't that much available. Mm-hmm. So it would skip that project as well. And then it would grant the...
well, I'm getting ready to go.
Oops. Judy, we can hear you. Judy.
Right?
Judy Amer. Oh, well. Somebody text her.
I'll mute it, Commissioner.
Okay, thank you. All right. Go ahead. Please proceed, Russell.
The next project that would be granted funding would be Windstream's Tierra Amarilla Exchange project in the amount of the requested amount of $323,303.
Yeah, I understand.
Okay, and then the next one that would be skipped is the Smith Bagley Blue Water Acres new tower build. Right. Requested about $500,000. So that would be skipped and not funded. And then the last project on this list that we funded would be New Mexico Surf, which is also called NM Surf Inc.'s Los Cerios project. what was actually requested by New Mexico SURF for funding was, let's see, here we go. 300, oops, let me get the right one from here.
I understand. You don't have to give me the details. I see.
Okay.
You're remaining underneath the, the cap.
Yes. And so with New Mexico,
let you do that. Okay.
With New Mexico SURF, the amount that they actually requested was $367,182. And the amount that would be awarded would be slightly less than that, 1.3% less, which is $362,488.39, because that brings the commission precisely to that $11,872,000 that's actually available. So that's how I arrived at an order that would award precisely the amount available. And the proposed order would state that, because it's such a small reduction from 367,000 to 362,000, less than 1.3% of the amount requested. The proposed order would state that the commission anticipates that this amount awarded will be acceptable to NMSURF. However, should NMSURF Inc. wish to decline this award because it's, maybe there's a razor thin margin for the profitability of this project, then the proposed order would provide that NMSURF may do so by filing a verified statement to that effect in this docket within 3 business days of the date of this order. Upon such a filing, the commission would issue a further order reallocating that amount or some portion thereof. The commission has actually done a conditional award in the past that was rejected. I think, I can't remember what the carrier was, but it was a very large reduction. It was like I want to say it was a $200,000 reduction on a $700,000 project. So it was not too surprising that the carrier came back and said, that's not going to work for us. But I think this should work. It's it's only a reduction of $4,693 on a project worth almost $370,000. So I think that'll probably work, and then the commission will be able to give exactly expend all the funds it's possible to expend this year. Now, NMSURF Inc. Is not yet an ETC. There's a pending docket open for its ETC status that I am the hearing examiner. I'm presiding over that. The hearing is scheduled for December 1st. The proposed order would state that should the commission deny ETC status to NMSURF, the commission would issue a further order reallocating that amount conditionally awarded or some portion thereof. So it would be a conditional award, a reduced and conditional award to NMSURF. But I think this should all work out. And so I guess with that, I'll take any questions.
Thank you very much, Russell. I really appreciate your detailed explanations. I have a question. The top section in the unserved category, there are 3 projects for which the cost per customer served is 10 times, more than 10 times greater than the cost per customer served for all the other projects. And I'm talking about White Lake area project, El Valle area project, and Clayton area project. Their costs, while the other projects cost per person are around $1,000 cost per person or less, much less. Some are, $100 or $200 per person, but these are $31,000, $33,000 plus, and $44,000 per customer to build. I think that's very expensive. And I think if that money were not spent on those projects, that money could be spent on projects that may reach other parties, a greater number of persons. Can you tell me anything about those projects? I mean, one of them serves 3 people, and I know that falls within our priorities of serving unserved communities first. But at this cost, I wonder if it's really is consistent with the spirit of the law, not the word or the letter of the law, to, you know, try to be cost effective in trying to serve as many people as possible. Do you know any details about these projects? I mean, my concern is, I guess, that rather than this being low income people, it may be people who can well afford, you know, some alternative to being served fiber optic. Can you tell me, do you have any information about these three, the recipients of these three, of the service from these three projects? One serves 3 people, one project serves 13 people, and another serves 9 people. Do we know any details about that? I mean, it's just such a shocking disparity in cost. I'd like some reassurance that it's, you know, really serving the right purpose.
Yes, Madam Chair, and I will turn it over to Eugene in a moment for some more information about those projects. I will note first, the Commission has, in the past 2 years, made exceptions, like Madam Chair, what you're discussing with regard to the prioritization of unserved or underserved areas. In each year, it was for a project by the same company, proposed project by Eastern New Mexico Rural Telephone Cooperative. I believe every project that they do is fiber to the home. Fiber to the home, you know, is the best guarantee that I'm aware of speeds, you know, of I believe, you know, 100 up, 100 down, speeds that really, you know, the best performance. But that involves, especially in Eastern New Mexico, laying long fiber optic cables to these homes. So that's why ENMR has typically in the past had the highest cost per customer served because of, you know, the great distances between its customers and you know, the servers of ENMR, and their choice to use, you know, the best technology. So the Commission did reject one of ENMR's projects last year and one of ENMR's projects the year before, based on the high cost per customer. And you've noted that all 3 of these projects do have that a significantly higher cost per customer due to the distance and due to the fiber to the home as an option. The Commission would be within, you know, it's perfectly within the law to make those exceptions to its general prioritization criteria. But if you'd like some more information, I can turn it over to Eugene if he has more information about those specific projects.
I would like that, and I see Commissioner Fishman was interested in saying something. Commissioner Fishman, do you still? Okay, fine. All right, well, yes, if we could have Eugene provide some information, I'd be grateful.
Mike Ripperger is on. I'm not sure if Eugene, perhaps he's not on.
I am on. Can you hear me?
Okay, great. Thanks, Eugene.
I just didn't hear if anyone heard me at this point. It didn't look like Madam Chair has left her office area.
We can hear you now.
Okay. Pretty much everything that Russell had indicated is correct. It is a situation where we're looking at a vast amount of different areas that is remote, and we're talking about the land of the fiber, and there are certain families that is there, and certain groups of individuals, and within those communities. So it is accepted to be very expensive doing that, doing this particular project. It was indicated that ENMR would not be able to I guess, financially do that completely according to the application. And it was filed in that manner. So I do believe it is up to the commission to make that decision if it feels that that is you can find the funds to be utilized in a different way or more efficiently with others that would get more utilize the broadband with more people. If that's the case, that that is up to the commission. But that is my understanding from the application, is that as Mr. Fitz has indicated, it is the technology of the fiber. It is the location of the remoteness of this, which is causing the high aspect of the funds.
Thank you, Eugene. Yes, I appreciate those facts. Do we know anything more about the socioeconomic conditions of the proposed recipients, or whether they have children? I mean, these are not criteria that are absolutely written into the rule, but we have followed them in the past, and I just wondered.
What I have, Madam Chair, Commission, is just the amount of residential address and the total population of what is the project is going to provide the service to. I do not have any specific, as you say, social background on if they are indeed being utilized the broadband for education in that manner or just for private use. I don't know. So that I do not know.
Madam Chair. So it looks like you're frozen. Eugene, can you hear me?
I can hear you.
Okay, well, so just a follow-up question on Commissioner Hall. Do we have any information about alternative solutions that might have been presented to these accounts that are these folks that are so expensive to hook up to? So for instance, do they have cell service there? And is there something you can do to beef up their cell signals so that they can, basically get their internet through tethering to a computer? Those kinds of solutions.
At this time, Commissioner Fishman, I do not have any specific on alternatives according to what the application said. I can reach out if the commission want me to. I can do that in any way to EMR to see if there is any alternatives that can be arranged or that is presently in the regional location that can be utilized for the customers in the case.
Okay.
I can do that for you if that's adequate.
So my thought is that going forward, I think Commissioner Hall is asking exactly the right question. That when we get to these really expensive per customer projects, we should be asking additional questions. And what alternatives have been considered, and what is the socioeconomic status that justifies such a high investment in such a small number of people? And at some point, well, I'll just leave it at that. We should ask for that extra information. So, Commissioner Hall, take it away.
Thank you, Commissioner Fishman. I apologize for the interruption. One computer wasn't charging properly. I had to switch to another computer. And I take it from your comments that you concur with my perspective here. Do any other commissioners have any comments on this subject or any other subject, or questions for Russell or Eugene?
Madam Chair.
Yes, Commissioner Byrd.
So I agree with your assessment on the cost. But as far as whether it's the intent of the law that they are the definition of rural, and the more rural we are, the more it's going to cost. So I think that it explicitly is what is intended under the law, is to help get broadband to rural, not semi-urban areas, which is what we tend to serve. When you got 671 people, that's urban. So anyway, but I think it's a fair question to say that's really expensive, and is it possible that we could serve more community members by not approving those projects, but rather some further down the line? I think that's a fair question at this time in what's going on, because the goal right now should be to get broadband to as many people as possible, and as those costs climb, those projects become fewer and easier to meet the cost. I think part of the ENMR Plateau's commitment to its customers is broadband via fiber optic. I could be wrong, but I'm pretty sure that is their. So they don't even look at other options. They want to get fiber optic to everybody, and I think that's a great goal. And because we have LTE at our house, it's not the best thing in the world. So anyway, if we want to switch them out, I'm open to that discussion.
Thank you very much, Commissioner Byrd. I appreciate that.
Madam Chair, if I may.
Yes, Vice Chair Maestas.
I think that was Eugene.
Who was it? Oh, that was Eugene. Okay, yes, Eugene. Please proceed. Yeah.
Voice is deeper.
Thank you. Thank you, Madam Chair. I just want to kind of hop on what Commissioner Byrd had indicated and made a statement as well. And I have to agree. Now, there is the disparity of the amount of the funds that is, the cost, I should say, is because it is in a seriously remote rural area. And of course, it will require a lot more of financially to put that infrastructure out there. And that is a natural aspect of just the construction itself. And that is up to the commission if you feel that these particular costs are going to take away maybe, other projects that may be able to give others, customers, more broadband compared to maybe the few that the rural would do. However, that still leaves the rural in the fact that they're not being covered in some ways because of the cost. So I tend to agree with that. That is up to to the commission to make that decision. But I have my understanding of all these projects that it's going to be utilized in a best way as possible to offer the rural areas the basic service of broadband, and that can be extended outwards. As long as you have the main vein out there, you can also kind of tapped off on that or interconnect from that area as well for the customer. So I think that in the long run, it's a good thing. In the short run, it may not be considered.
Thank you, Eugene. I appreciate it.
You're welcome.
Commissioner Vicente Aguilar, do you have any observations or comments or questions?
Madam Chair.
Yes.
I'm listening to the discussion, and right at the moment, I don't have a comment. Thank you.
Okay, thank you very much.
Madam Chair?
Yes, Commissioner, Vice Chair Maestas.
I had some questions for Russell or Eugene. Obviously, there's a significant increase in costs per customer in the unserved category when you get to the ENMR projects. However, we would essentially wipe out all these projects for one applicant. And so I'm a little concerned about the equity and fairness around that. And I think Russell mentioned that we've done this before to ENMR. So my question to you, Russell, did ENMR protest that removal of their project from the initial prioritization last year? And if so, what were their reasons? Only because, yes, cost per customer is one of our criterion, but I mean, it could be pretty arbitrary because I'm looking at the overall cost of the project, for example, of the White Lake area, and 69, just under 70,000. It's not a significant amount of money, but certainly the cost per customer is. And so would we be opening ourselves up for some kind of protest by ENMR if we just say these are just much too costly per customer? Russell?
Commissioner Maya says, in the past 2 years, in each of those years, one project, and I believe also in the first year of the broadband program, there was one project in each of those years, an ENMR project that was denied funding based on the high cost per customer. I believe in each of those years, certainly in the past 2 years, there were other ENMR projects that had relatively high costs per customer compared to the other projects, but were still granted funding by the commission. So this would be the first year in which ENMR, all of ENMR's proposed projects would be, if the commission goes down that road, would be denied funding. That doesn't, there haven't been any protests filed by ENMR in the past to the commission's decisions. But again, in the past, not all of their projects were denied funding. Now, I don't see a legal basis for protests there because, for one thing, under the Rural Telecom Act, I mean, there's no indication of how the commission should prioritize applications. So all the commission has is its own rule. I mean, I think there would be some reasonable guidelines that would have to be read into it. It can be something completely arbitrary, but the things that the commissioner is considering now, the cost per customer served, and prioritization of unserved areas over underserved areas, these are obviously proper public considerations in the public interest. So I don't think even if the commission did deny funding to all three of these projects, the ENMR would have a legal basis to protest, and they haven't protested in the past. One thing I would note, since we're discussing alternative criteria, is that Madam Chair had mentioned that in the past, specifically I think 2 years ago, when the pandemic started, was it 2 or 3 years ago? The commission did list as an explicit prioritization criterion serving residences over serving businesses, because there was some indication there was a project, I believe, that would have mostly served a business area, because due to the fact that children needed access for educational purposes. Perfectly proper. I don't believe the commission has ever applied a socioeconomic, the socioeconomic status, the income status of the potential recipients, the potential subscribers who will be benefited by the project. And there's a good reason for that. That is because this broadband program, just like the SRUSF in general, except with one exception, which I'll talk about, is based basically on the federal high cost fund, which is the Connect America Fund. And that the purposes of both the federal fund and our broadband program fund is to fund projects whose costs are prohibitively high to the carrier, such that they would not undertake those projects without funding from a federal or state source. They're high cost. They're to support high cost projects, and those are rural projects. Rural projects are always the higher cost projects due to the distances between people. Now, both the federal fund, the federal government, the FCC, and our commission provide relief to low-income broadband and telecom customers. The federal government does that through the Lifeline program, which provides discounts for people's bills. And the commission does that through its matching amount in the LITAP program of $3.50, an additional discount. And so even though I don't think the law would prohibit the commission from considering the socioeconomic status or income status of recipients, beneficiaries of a high cost project under the broadband program, I would advise against it. For one thing, like I said, that's not the purpose of the broadband program. Plus, it's not. It's to the extent, like, the two issues truly are separate in the sense that these high cost projects, even though it may cost far more to extend a fiber optic line to a customer, they're not going to be charged more by the carrier. The carrier will charge their usual rates for broadband service to that person, even though it cost $20,000 to reach their house, as they would to any of their other customers. So if the customer has trouble paying that bill, that is truly an issue for the Lifeline program and the state's LITAP program. In other words, it just looks at the bill, not the project, not how much it costs to connect them, but the bill and whether they can pay it. So I would just note that for the commission.
Thank you for pointing that out, Russell. Yeah, just one moment, Commissioner Fishman. I appreciate you walking through that. I actually, when I mentioned that, I was just sort of grasping for criteria to use. And I take your point that to the extent the law recognizes the inability of some people at lower incomes to meet their bills, there are mechanisms in place to help them with their bills. So that should not be a criteria here, since it is not delineated in our law, and we have provisions elsewhere. And you distinguish that from the need for children's need for education during the pandemic as something that is not addressed similarly by the federal or state government, and so therefore it was rational. Does that sum up what you're saying pretty well?
Yes, Commissioner, and I just to give a little bit of a gloss on that, what I'm saying is that the high cost and the rurality, that's the ruralness of a project, which are closely related, have entirely separate considerations.
Yes.
From who's going to benefit, whether they can afford the bill or not. They really are very separate considerations that don't really match up. Whereas, when the commission decided to prioritize projects that serve residences over businesses, that really was about expanding access to the people who most need it at the time, which the commission determined was kids who needed it for their education. So I think that's why the commission shouldn't consider the income status of the people who will be served by this project.
I understand. So therefore, really, our best guidance is the cost per customer served. Is that correct? Our best
yes, and
the
commission could definitely decide to deny all three of these projects fundings on that basis, make an exception to that. And I could even right now, share my screen and show what the reallocation could be. And then the commission, I know we've done that in the past.
Yeah.
And I'm ready to do that if the commission would like me to do so. And then if Patrick would share the screen, if the commission would like me to do that.
I would like to do that, but I would like to go to Commissioner Fishman because I know he's waiting to make a
Madam
comment.
Chair, that was me. I just wanted to continue.
Okay, yeah. Vice Chair Maestas.
Thank you, Madam Chair.
Yes.
I wanted to remind the commission that if you look at the bottom of the underserved projects, there's another one that has a distinctly higher cost per customer, but the overall price is over 2 million. And if you look at where that project lies, it's also in Commissioner Byrd's district. And I feel like if we follow this train of thought, we could potentially remove 4 projects from one district based on cost per customer. And so I'd like the commission maybe think about what staff has come up with to balance the budget available before we open this up and consider reallocation. And also, I had a different question for Russell. Russell, does New Mexico Surf currently have ETC designation?
Commissioner Mass says no.
Okay, so let me stop you there. So why are they even on this list for projects to be considered if they don't have that designation? And I realize it's going to be an action item for us on December 1st, but I'm even wondering why they're being considered in the absence of having a current ETC designation.
Commissioner Mass says the reason for that is that NMSurf did file a timely ETC designation petition, and most of the delay in that process has been on my part, and I have assured NMSurf that they will not, that my delay will not affect their ability to receive awards this year. The commission has granted conditional awards in past application cycles where an ETC petition was pending. Now, last year, the commission did not consider OSO Internet's applications for broadband program funding because they had filed their petition quite late. I believe it was a month or less than a month before the October 1st deadline for having ETC status. Now, again, NMSurf will not meet that deadline, but I plan to, if I recommend to the commission as the hearing examiner that NMSurf be granted ETC status, based on the testimony and the record and the hearing, then I will be recommending a variance because, again, this was my delay due to the press of other business, and I don't think NMSurf should be penalized for that. And as I said, the commission has done conditional awards in the past.
As a follow-up, why couldn't we take action on ETC designation for New Mexico Surf on this agenda and have it precede this current action item that we're deliberating?
Commissioner Massis, that's because that is a litigated proceeding with staff as a party and with NMSurf Inc. as a party. The commission, I have done a number of, and Hans has done a number of them as hearing examiners, proceedings for ETC designation, specifically for broadband program purposes and also related, for the same service area, Lifeline, et cetera. In all of those cases, staff and the applicant or petitioner have reached agreements. I can't guarantee that will happen in this case. It's usually what happens, in which staff ends up recommending granting the petition. I don't know that that's going to happen. I can't foresee that. It is there are factual determinations to be made. There is testimony that is beginning to be filed, and it will go to a hearing on December 1st. So, Commissioner, it would be premature for the commission to make a decision on that pending petition at this point.
So, Russell, we're turning away almost 20 million in shovel-ready projects because of our budget limitations. So will this subsequent action on New Mexico Surf open us up to protest by those applicants that didn't get selected?
Madam Chair, Commissioner Maya says, no, there wouldn't be a proper basis for a protest. And we've never received one in the past based on a conditional award where an ETC petition was pending. And again, as the proposed order states, even though it would be in December that the commission would be making a decision on that petition, it would the commission could reallocate that money. The commission has in its rule has this schedule set up, to make these decisions on October 15th, et cetera. And then there's a potential motion for reconsideration or protest process. But if there's a change in December, there can be adjustments made to reallocate that money, because these projects can last up to 3 years. And so the commission could even make a decision in December to say we're going to reallocate that money because NMSRF, was ultimately not awarded funding. So the funding wouldn't simply go away; it would be reallocated, and that's actually what the proposed order says.
So on the 3-year limitation, Russell, in looking at the basic math for the broadband fund, I don't recall there ever being any balances being reverted. Have we had that happen in the past? And did we have any unused previous funding revert back to the fund?
Yes, Commissioner Myers, there have been projects that have come in under budget. And so there hasn't been as much dispersed on those projects as was initially requested. So that's resulted, well, that actually wouldn't be a reversion, it would just be less money going out. And there's also been a few projects that ended up not going forward based on changed circumstances. I believe there's a few CenturyLink projects, and that didn't result in a refund or a reversion. It just resulted in the company not requesting disbursements for the projects. This would be essentially any disbursements that would be pursuant to any awards made this year would start next year. That's why, in each docket, application docket, the next year is listed as, in the matter of applications for 2022 and 2023 broadband program support. In other words, that's the first year that the actual disbursements would begin to go out. Sometimes companies don't request them in the first year because they don't start the project until the second year. But the commission would be able to reallocate, if NMSRF did not receive ETC designation. There'd certainly be time for it, even before the end of this year.
Just to give up the floor, Madam Chair, I still think that if we take those 3 projects out of the unserved, it's really not significant enough to fund other projects. And then if we apply that same criteria, the cost per customer, then we're going to have to kick out that Elida West project. And so I don't really see at this late stage us to reopen all these projects and reallocate the funding should a majority want to remove these projects that are that do represent a pretty high cost per customer. So with that, Madam Chair, I'll give up the floor here and keep listening.
Okay, thank you very much, Vice Chair Maestas, for your comments. I appreciate them. I do understand what you're saying, but I would say that I don't think we want to. I think what guides my thinking is the ability to have funds that can be spread over the greatest number of recipients who are rural. And, cost per customer is a metric that we can identify. I don't know that I agree with you about projects. I understand what you're saying about the White Lake area project. It doesn't cost very much. Its total price isn't very much. But the other 2 projects, El Valle area project and Clayton area project, are both close to $500,000 each. I think that is money that could be possibly applied to other projects. Plus the 2.2 million from the Elida West project, that adds up to real money that could be used to fund other projects. Maybe not this year, but certainly next year. And I believe the money can stay in the fund for the next year. So that's my thinking on that. And I agree that if we were to take out, if we were to deny funding for the ENMR projects that have the high cost, that we should deny funding to the Elida West project as well. And one other thing I would say is, yes, I certainly did notice that District 2 was the district in which all of these projects exist. And but I don't think that can be part of our calculus. I mean, it's nowhere stated in the statute or the rule or that we need to protect, one district from being affected, even though it does fall out that way. And I would also point out the District 2 is, the west 3/5 of the state. So it's a pretty large district in terms of its footprint compared to the others. So that may be, the fact that a lot of these are in District 2, it could be an artifact of the size of District 2. But in any case, I just wanted to make those points. And I heard some. Yes. Who is that? Commissioner Burke?
This is Eugene. Can I make a comment?
Oh, Eugene? Oh, yes, Eugene.
It's possible.
Yeah. Yes.
Certainly. I'm kind of, from the way I, have been evaluating these projects, and, although it seems like majority of these large, high-cost projects that have a wide margin per customer seems to be in Commissioner Byrd's territory. But I have to say that it's also an area where it is a highly rural area which has vast amounts of distance between customers, as well as its terrain, and the infrastructure is going to will have a higher cost. I like to point towards previous docket, in this case will be 200099, which basically gives two examples of the same situation in which the commission had made a decision. And I think Russell Fitch was trying to allude to the customer, and the customer was Penasco Valley, which was a Pataco Road project, fiber to the home project, that was also had a wide cost customer area. But again, that is an area where the terrain and the distance and how much it will cost in order to put that project out there. And the other example, which was unfortunately was a business customer, which is part of CenturyLink, also on that same docket number, which was looked at as maybe just seems to be serving the business as well as not maybe residential areas. I think that was another decision by the commission to kind of omit that. So those are two examples. But my concern is that if you make a criteria of not covering the areas where it is going to be a high cost or a wide margin, then that area will always seems to struggle in trying to get broadband out there that can be interconnected, because the infrastructure has been laid through this initial expense, and it is not just the customers that is at the endpoints now that I think the commission should be concerned about. It's the customers in the future that can come off of that as well. So that is allowing that. So, my thoughts is that it seems difficult in the first hand of thinking that you could offer more now but you can also, I look at it that you will also have the ability to offer more later to that particular area that right now is having difficulty being supplied broadband. So that's just my opinion on that.
Thank you, Eugene. I appreciate your comments.
Madam Chair.
So we have to strike a balance. Yes, Commissioner Byrd.
Thank you, Madam Chair.
Mm-hmm.
So I understand, as I said before, I understand where you're coming from. And I don't think that's inaccurate to think that way. It's always good to be conscious of how the money is spent. However, I think the very intent of the law is to reach the rural areas. And by definition, there is nothing more rural than 35 miles of cable to hit 3 people. That is the definition of rural. And I think excluding them because it is going to cost more per customer is actually contrary to the intent of what the rural broadband is intended to serve. And so with that, I'm going to say I will move the motion as presented, or the order as presented.
I'll second that.
Okay, we have a motion and a second. Do we have discussion on this? Okay, well, I would only say one thing, and I think we have used the cost per customer in the past as a guide, but I also do appreciate that if you never cover the people who live farthest away, they never get covered, and there's an element of unfairness there. The difficulty is we don't have direction from the law about discriminating between real rural and not so rural. So, but I'm, I guess I feel that everybody who falls under the category of rural has to be considered rural, and they all have to be considered equally because we're not given instruction how to distinguish. So that's my basis for thinking, but I can well appreciate the other side. And I think it's a balance that we have to strike. And I think Commissioner Maestas was on the right track, and at least looking at the total cost of the projects, where White Lake area project, even though it's really expensive per person, is otherwise quite affordable. Whereas the other 2 projects in the unserved category, they cost more, but they're not outside the ballpark of most of the other projects. So, at some point it does start to get kind of fatiguing on how you discriminate among them. I would say, just from looking at the numbers and talking about those 3 projects that way, the only project that is both high cost per person and high cost overall is the Elida project. But even so, it's not the only project that is a $2 million project. So I'm inclined to agree that, under the circumstances, I suppose this would not be an irrational way to proceed as well, to approve them all. I'm not as comfortable with spending money that way because I prefer, as you know, to just be able to have more funds available for the most people. But I appreciate the reasoning that supports this motion and second. So before we take the roll call, does anybody else have any other further discussion? Hearing none, can we have the roll called, Mike?
Commissioner Fishman.
Sorry there. Nay.
Commissioner Maestas. I'm sorry, I didn't catch that.
Yes, aye.
Commissioner Hall,
No.
Commissioner Byrd,
Aye.
Commissioner Vicente Aguilar.
Aye.
The order passes 3-2.
Okay, thank you, Mike.
Madam Chair, just
Yes, Commissioner Fishman.
yeah. So I completely understand the direction the vote went. Good arguments both ways, and so I just wanted to let folks know that.
Sure.
Agreed.
Yeah. Okay, so we come to our last case on our regular
Madam
agenda.
Chair?
Yes, Commissioner Fishman.
Sorry to interrupt one more time, but I need to go now, and I've got a wife and a vacation and the activities that we're scheduled for.
Okay, I guess we'll
Enjoy.
slog through this last challenging case without you.
I trust you guys implicit.
Okay.
Take care.
Well, drive carefully. We'll see you when we see you. Okay, thanks very much. This is case number 22-00214 UT. In the matter of the Commission's 2022 annual report to the legislature regarding the status of the State Rural Universal Service Fund, as per section 63-9H-6Q of the Rural Telecommunications Act of New Mexico. Russell Fisk will present a potential order adopting a report to the legislature. Russell, would you like to present your order?
Yes, Madam Chair. So the order is just a simple order that I've drafted to adopt the report. So I'll discuss the report a little bit. I have previously provided this report to the Commission. I believe I provided it for last week's open meeting, but based on the decision to go forward this week with making broadband program awards, I've updated the report, and the updates I made turned out to be accurate because the Commission adopted the proposed order that I had proposed. So the report addresses that excuse me, let me just open it up so I have it in front of me. So if you want to look at the report, I made track changes from last week's version to incorporate on pages 4 and 5 information about the Commission's decision that the Commission just made. It gives a summary of 2022's applications, the funding they requested, the total of $11,872,000 available, and then it describes that the Commission awarded funding for 11 proposed projects, et cetera, for unserved, which is exactly what the Commission just decided because the Commission adopted my proposed order. And it would state that the Commission was compelled by the $30 million statutory cap to deny approximately $19,117,740 in requested funding for 14 projects that the Commission otherwise would have granted, which is what the Commission stated last year with regard to the fact that the Commission had only 11.5 million available and had to deny funding for 27 projects, requesting a total of 25.5 million. So, this just describes the ongoing issue. With regard to any other part of the report, there are certain requirements for reporting that the Commission, under the statute, the Rural Telecommunications Act, as amended in 2021. And the report, as I said, as I previously stated, is set up just like the second report, which was the second annual report, which the Commission provided last year. And indeed, the second annual report would be an exhibit to this report. So this report, is leaner in that it doesn't reiterate things that apply from year to year, because the second report is attached and it's more detailed, but it just gives an update on all these areas to the legislature. And the order would simply adopt the report for transmission to the legislature on or before tomorrow, with a brief cover letter, and both the report and the cover letter would be signed by Madam Chair on behalf, actually just the cover letter would be signed on behalf by Madam Chair on behalf of the commission, which is what happened last year as well. Even though Madam Chair wasn't the chairperson, then it was just given to you, Madam Chair, to sign the cover letter, transmitting the report to. It goes to all of the members of the Science, Technology, and Telecommunications Committee of the legislature. And so with that, I can take any questions.
Commissioners, any questions for Russell?
Madam Chair?
Commissioner Byrd.
I will move the order as presented.
Okay, I have a motion. Do I have a second?
Second.
All right, we have a motion and a second. Any further discussion on this order? Hearing none, let's take the roll.
Commissioner Maestas.
Aye.
Commissioner Vicente Aguilar.
Aye.
Commissioner Byrd.
Aye.
Commissioner Hall.
Aye.
Orders approved by a vote of 4-0.
Thank you, Mike. That does it for the cases. Let's move on to communications with Chief of Staff.
Good afternoon, Madam Chair and members of the Commission. I'm not sure if I can actually proceed without Commissioner Fishman being here, but I'll do my best. Honestly, Madam Chair, I don't really have a lot to report to the Commission today, but happy to discuss any items that you would like to discuss.
Well, I can't think of any. Commissioners, anybody have any questions or other items they'd like Wayne to discuss? Hearing none, Wayne, I guess you're off the hot seat for the day.
Thank you, Madam Chair.
You're welcome. Okay, moving on to communications with General Counsel.
Madam Chair, Commissioners, OGC has even less to discuss.
Oh, wow.
My favorite attorney.
All right, thank you. How about let's move on then to communications with commissioners. Commissioners, anything to report?
Madam Chair.
Chair? Yes, Vice Chair Maestas.
I just wanted to note that the meeting of November 16th conflicts with a NARUC fall meeting in New Orleans, and I'm making tentative plans to go. So I'm wondering if we can afford to skip that meeting. I know we typically consider that, but I thought I'd throw it out there and see if any other commissioners are going to NARUC this fall. And I think the conference is, let's see here.
2 weeks in a row that we don't.
That's November 12th through the 16th, I believe.
Great. Yes, Vice Chair Maestas, I appreciate you bringing that up. I too thought about that, and I have two other things I could attend, if not NARUC, during that week. So it would, even though we have very busy agendas, I think that it's probably a good idea for commissioners to be able to be free to attend that meeting and or other conferences that we need to attend. That is part of our job. So would other commissioners have any opinion on that? About
Madam Chair.
Yes, Commissioner Vicente Aguilar.
I will be attending the conference in New Orleans as well.
Mm-hmm. Okay. And Commissioner Byrd, any comments?
No, the next week is Thanksgiving.
Oh.
So that could make 2 weeks without a meeting.
It's a long time. That's a long time. Any suggestions, Commissioners?
Friday.
Yes. Commissioner Vicente Aguilar.
I'm okay to go ahead and still have the meeting on a Wednesday at 9:30 there's no problem for me to juggle my schedule. Thank you.
Okay, thank you for that. Commissioner Maestas, what's your thought on that? I know in the past I've done that too from a NARIC meeting or other meeting where I just step away from the meeting and get on Zoom.
Well, Madam Chair, if I may interject.
Oh yes, Commissioner Byrd.
The NARIC meetings usually go through the Wednesday noon, and then we fly home Wednesday afternoon. Tired on Thursday. How about we suggest doing the meeting on that Friday, which would be the 17th? Sorry, I'm not looking at the calendar. I guess
Friday's the 18th. Oh wait, 18th. Yeah, we're talking November.
Just moving
right?
the meeting to the 18th so that everybody's back home and don't have to miss any of the meeting by traveling or miss any of the conference by being in the meeting.
I think that would probably work. I think that's probably a good idea. I think it's a good idea to have at least one meeting in that 2-week period, especially with Thanksgiving coming up after that. Commissioners, anybody else want to comment? Does Friday sound good?
That's a great idea.
Yeah. Commissioner Vicente Aguilar, does that work for you?
Yes, Friday's fine.
Okay, wonderful. Great. Thanks very much. Let's see. Let's make sure that gets reflected. Well, on our calendars anyhow. I guess we don't have an agency calendar. Is there anything else that needs to be done to memorialize that? Well, we need to send out a notification, I guess. Mike, is that correct? Would we have to notify that meeting is canceled to the public?
Yeah, that's our normal protocol, is we would issue a notice of cancellation of the regularly scheduled meeting and a notice for the meeting on the substituted date.
Okay, great. Thanks. Okay, commissioners, any other comments to share with each other?
Madam Chair?
Yes, Commissioner Vicente Aguilar.
Thank you. I'd like to share with everyone listening on the meeting that my assistant, Jennifer Baca, she will be leaving us. She accepted another job elsewhere, and I just want to say thank you so much for helping me for the last 3 years. It was just wonderful communicating and getting things done, and I will miss her. So I don't know if she's on the phone or if she's on the call. Jennifer, are you there?
I don't see her name or another phone call.
Oh. Okay, I did tell. Oh, are you there? Oh.
Yeah, we can hear you.
I'm not sure. Jennifer?
No, she's not on. I think that was Commissioner Byrd just saying we can hear you, Commissioner Vicente.
Okay. Yeah. So you can certainly give her a call or send an email to her that she's done a wonderful job for our agency. Thank you, Madam Chair.
Thank you, Commissioner Vicente Aguilar. Do you know when her last day is?
Her last day will be Friday. We talked about it. We talked about this in the springtime, and during the summertime, she did share with me that she's going to start searching for another job starting September, and they took her right away, and they offered her the starting date, so she took it. I said, go take it, and I'm working with Wayne to find the replacement for temporary basis. Thank you, Madam Chair.
Oh, well, thank you, Commissioner Vicente Aguilar. I'm so glad you told us. She will be missed, I'm sure by you, but I mean by everyone. Jennifer's been there since I have been at the commission, and before that as well. I mean, before I was on the commission, and I know her to be a really intelligent, really efficient, hardworking, informed employee who's always gracious to people. And I mean, incredibly hardworking, even through health problems. I have nothing but admiration and respect for her. And I'm so sorry to see her go. But on the other hand, if she has, brighter horizons somewhere else, then I certainly want her to be able to take advantage of them. And I hope you'll convey to her my fondness and my well wishes for her future. She's one of the people I really, really have respected and appreciated here at the commission. So please give her my best, and I'll text you for her telephone number. I want to call her too. But thank you for letting us know.
Madam Chair?
Yes, Vice Chair Maestas.
I guess since we're recognizing individuals, I just wanted to recognize Sayuri Yamada. She was in charge of governmental affairs for the Public Service Company of New Mexico. She is moving on to another endeavor, but I know we don't typically see her. We see her roaming the halls during legislative sessions, but Sayuri has maintained a very high profile here in the community of Santa Fe, getting involved in other things and contributing to the community. And I know she's going to continue doing that, but I just wanted to recognize Sayuri for her service, not only on behalf of PNM, but on behalf of the ratepayers of PNM. Thank you, Madam Chair.
Thank you, Vice Chair Maestas. Well, one thing I wanted to mention on a different topic is I appreciated the bench request questions that you and Commissioner Maestas generated. I think that's being proactive, and I just wanted to say I appreciated the plans to develop that workshop and the continuing workshop. I know I'm very interested in more long-term resource adequacy and transmission. So I was going to mention that idea in Commissioner Communications as well, that we should have another, at least one other workshop. But if we can, address both topics in the same workshop, that would be a good thing. Because I think the workshops, first of all, help us all communicate better together in a non-adversarial way, and then it gives us food for thought that permits us to issue things like bench requests or other inquiries that I think really helps the commission become more effective. So thank you guys for doing that. And I wholeheartedly concur that we should do another workshop, and I look forward to it. So we'll make plans.
Madam Chair?
Yes, Vice Chair Maestas.
Despite my low blood sugar, I just wanted to recognize you for moving on as a finalist in the PRC, the appointed PRC commission selection process. I don't know if Arthur O'Donnell, I guess he's now your competitor there, Chair Hall. But
that was my assistant. My assistant is there too.
Oh, that's right, Colin. So yeah. Anyway, I wanted to recognize Arthur, Colin, and you for moving on to the questionnaire phase.
Well, thank you very much. I appreciate it. I guess we're all drinking the same Kool-Aid or something, but we'll see how it goes. It's a very exciting time for the commission. And to the extent any of us can move forward and help with the transition, I'm sure we'll all be glad. So thanks very much. And if there are no other comments from any commissioner, going once, going twice, we're adjourned.